Josie, you can turn your recorder on also. We're doing double recording, so we don't have to share files here, so we'll each have a recording available. All right, so we are on the record. Pardon me? No.
Okay.
I'm going to give some introductory comments, talk a little bit about the procedure of the hearing, and then we'll go into actually the process and go from there. So this hearing is called under the Colorado Municipal Election Code. It is not subject to any other law as far as procedure. So it's not a court of law. It's not even something under the Administrative Procedures Act. It's simply a means of getting out evidence on the record to deal with this protest against the petition. So as such, you don't feel the need to object to hearsay or things that formal. You don't need to do that. It is not a formal hearing in that sense. What you do need to do is go in an orderly manner. So the way that we're going to do this is the protester has the right to go first, because that's the reason we're here. The petition was protest. So Mr. Mitchell will make any opening comments that you'd like. After you make opening comments, you can either present evidence yourself, you can call witnesses, and then the petitioners, Mr. Fike and Ms. Langley, can collectively, you can agree to have one of you as a spokesperson, or you can both ask individual questions. It's up to you. And you can ask questions of Mr. Mitchell and any of his witnesses. But we'll do that in order. Once that side has completed all of their evidence, then the petitioners will have the right to make an opening statement and call witnesses, present evidence. Any documentation that's presented as evidence will be entered into the record. I will make a note up front that already included in the record is the initiative petition. There's two separate petitions, so both of those are in the record, and the objection is in the record. So those three things are already entered into the record, and since I have hard copies here, I'm going to mark them A, B, and C. And the designation of numbers versus letters is arbitrary because this is not a court.
Which one's which?
So I am marking
As orders are filed?
Pardon me?
As orders are filed, ABC?
Yeah.
Do you not have the judge's order in evidence?
It is not relevant to this hearing.
Okay.
You're welcome to introduce it if you like, but it's
I
not.
will.
It's not on its face part of this hearing.
Okay.
So this is the petition I'm looking at. I'm looking at a way to differentiate these two petitions.
The dates.
This is submitted by a circulator of Russell Fike on October 12th, and I'm going to mark that as A. And then the other one is circulated by Beverly Langley. We will see that's October 19th. We'll mark that as B. And the objection from Jake Mitchell, we're going to mark as C.
I have one question for you.
Yes.
The statement of sufficiency that Clerk Hart prepared that set the deadline for Jake, do you not have that?
I don't.
Can I get a copy of that from her right quick?
You can ask for that.
Josie, can I have a copy of your statement of sufficiency, please? I'll give you a quarter for it.
I think you'll have to.
Just run me a tab till we're done.
Okay. Is there any procedural questions before we start? It really is something that my intent is to get everybody's comments out that feel they need to have something to say. If those comments and the evidence is not relevant, then I'll determine that through my findings as I reach my conclusion, and which I should mention. I am obligated.
The statement of sufficiency that you put out and published, should I make... This hearing is specifically under 3111.110,
Yes.
is that correct?
Yes.
Okay, then I want to object to it right up front. on the following grounds.
Let's wait till you're
My
ready
turn?
to
Okay,
testify.
good.
Yeah.
Alright.
Anything like that will take into consideration as I do my findings.
Okay, good.
Okay. The hearing itself needs to bear that out. Okay, Mr. Mitchell, you're welcome to begin. And if you call, you're welcome to come up here and either sit or stand, whatever you're comfortable with. If you'd like to call witnesses, they can come sit up here.
Okay. Sorry, I have my written thoughts because I need to get this in order before I present myself here today. But first and foremost, I'd like to thank you, and I encourage you to stay, Beverly, if you may, to hear me out. But thank you, Judy, for coming all the way from Alamosa, and the other concerned citizens in the town for listening to this objection. As of recent, I've done extensive research in municipalities and the rules that govern them. However, with this being said, I'm still a novice. So, in situations where I lack the knowledge or understanding of some of other people, I'm going to try to use my common sense in that place. So, bear with me. As my letter stated, my objecting to the People's Ordinance on 3 primary grounds. The first one is the People's Ordinance would create inefficiencies in our local government to perform standardized routine processes where current processes are in place to protect the rights of the minority and enable the rule of the majority. The second one, the People's Ordinance would create greater inequities among town members and open the door for local elites to play a disproportionate role in our local government. And last, the third one is the People's Ordinance is vexatious in the light of recent actions of the proponents. Now, I would like to address these individually as we go through them, but now I believe that, personally, I believe that people should govern themselves. Absolutely. And that the more direct and decisive the rules are, the more effective and efficient. However, like our Constitution, this only works in a God-fearing society, where a belief in a supreme body are lacking. More rules are needed to address the problems. Now, through this hearing, I hope to bring light to the fact that if we use the current rules that are in place and become active participants in our local government, this ordinance is not needed. So, by the end of this, what I hope to do is I hope to ask proponents to withdraw their petition and that they understand how detrimental it is to our community. But that's probably not the case.
I doubt it.
I know.
I guess I'll just address these individually. So,
You're welcome to present however you'd like to do.
well, first off, Jeff, you never openly answered my questions.
Let me catch you up a little bit
Okay.
there.
Say my question.
Procedurally, yes, you're presenting.
Yep.
And he has a chance to ask you questions. Once he presents, you'll have the chance to ask him questions.
Okay.
Okay?
And so this is opening statements?
Yeah. Well, it's opening statement and presentation of evidence, whatever he would like to do.
Okay. Well, I'll go into the first point then. The first point that says that the ordinance would create inefficiencies in our local government to perform standardized routine processes where current processes are in place to protect the rights of minority, enable the rule of the majority. Now, I understand this only relates to the ordinance in our town, but no organization would conduct business that affects the health, safety, and well-being every other year. I don't know of a business that would do that. And these inefficiencies may include, but are not limited to, the delays to implement change, corrections, or additions to the town ordinances. It add additional procedures where current procedures provide ample power and protection to the board as well as to the town members to change, add, or protest the ordinance. And this petition completely handicaps the town board in a response to an emergency. Plus,
That's not true.
your proposed ordinance adds undue expense to the town through additional hearings, added ballot items, and lost time through educating electors, preparing ordinance to vote, publications, etc. Lastly, this ordinance would initiate the process to eliminate the power of the board. If the board does not have any power to govern, why is it here? And at that point, why not do away with the board of the town officials and then unincorporate our community? But we have to be careful about that fact because the Lincoln County officials, the commissioners and sheriff have already expressed an explicit disinterest in managing the affairs of our municipality if there is not an absolute need to do so. And actually, in talking to the town officials, they said that they prefer that Arriba stay Arriba and not unincorporated.
Me too, see?
A second point. The People's Ordinance would create greater inequities among town members and open the door for local elites to play a disproportionate role in our local government. With this proposed ordinance, I believe that it would give greater power to an organized individual or group that could inform or misinform the citizens of Arriba to block or implement certain action. Currently, we have a self-appointed community organizer in our town, Mr. Fike. And as I've seen from our current president, a community organizer tends to be a great orator and ramrodding their personal agenda. However, they lack the ability to listen to the needs and desires of the citizen as a whole they claim to represent. Now, Mr. Fike and Ms. Langley, from my observations, I believe your ulterior motive is to play a disproportionate role in our local government with this ordinance. Now, we'll have questions at the end of this and we'll have a time to defend yourself. I want to be careful how I present this, but this is my opinion. I believe that you want to play a disproportionate role in our government with the following facts. I believe this is evident in the fact that you, Mr. Fike, are posting opinions and comments on your chalkboard trying to educate the public in an effort to persuade them to your agenda. I believe this is evident in your so-called newspaper, which provides no news, but rather a one-direction forum that allows no public comment. Ms. Langley, I believe it's evident in the action as you purchase property near the town hall and host closed meetings to educate your followers. I believe it's evidence in the fact that the signatures on your petition, nearly half a dozen registered to vote the same day they signed your document. And I believe this is most evident in the fact that neither of you are running for one of the 4 positions on our town board. I would think that if you are so concerned with the happenings in this community, you'd want an active role on the board and not try to influence from the outside or be antagonistic. Also, Ms. Langley, if you are so concerned with the affairs of our community, why are you trying to implement a detrimental ordinance to the town and its citizens where you are actively trying to sell all your properties in Arriba?
That doesn't mean.
Sorry, Dad.
Let's
And you're
keep.
stating that as a fact?
No, just wait a
Yeah,
minute.
you know
wait a
I'm
minute.
moving.
Can you
Wait a
define
minute.
the fact?
Wait a minute. Let's reel it back a little bit. The elements that we're talking about is the elements of these 2 documents, the petition itself. Not do we want do we want the ordinance? Do we not want it? That's not really relevant to this hearing. So what we want to address is, are these documents legally able to proceed toward an election? So I understand you have opinions, and everybody has opinions, but we'll want to limit the conversation. I don't have authority to say this is a good ordinance or this is a bad ordinance. That's not my place. What my place is to do is to say, are these petitions adequate to move forward toward an election? So try to limit it to that context.
Well, I believe they do not look out for the well-being of the community itself.
And you're you're on record saying.
I mean, I'm not objecting to their signatures. I believe they're a valid point.
Okay.
So,
Okay.
and I believe I expressed that in my initial letter.
Mm-hmm. Yeah. And you're I don't want to stifle any comment here. If you feel like you need to say something, I want it said, but I don't want it to turn into a personal confrontation either.
Well, and that's my opinion, Beverly, and there'll be ample time for you to. That's why I suggest that you stick around for this, because the next one that the People's Ordinance is vexatious in the light of recent actions of the proponents. This is a very difficult.
It's specific. Come on, say it.
My goal of this is not to offend anybody, but my comments do speak to your actions in conjunction with this ordinance, and I believe they may endanger the welfare of our community.
How so?
I'll get to that. Mr. Fike, I know we briefly discussed this via email, but for Ms. Langley's benefit and the benefit of the other ones present, I'm going to carry through with this. Now, as I mentioned in our email, I may have been confusing when I used the word vexatious, which I understand to mean annoying, frustrating, or worrisome. And I believe that this ordinance, in conjunction with both your actions, display a disregard for the welfare of the town of Arriba and its citizens, and that is very worrisome to me. I believe this initiative is only part of a larger picture. I believe it is like a snake you chase into a woodpile that only shows you a small glimpse of its body. I don't know if this initiative is the beginning or the end of what your true goal is. But as I add up the small glimpses of your action, I'm alarmed by what your intentions are or could be.
Such as? Be specific.
Don't speak out of turn,
Okay,
please.
sorry.
I'm getting to that. To answer your question, Mr. Fike, I believe that you're trying to provoke something in the town of Arriba. Someone or something to accomplish something else than what you're telling us. Your actions of provocation include badgering the town clerk to the point she felt threatened, enough to call local law enforcement and to have a temporary restraining order in place. Not only are your antics in the board meetings less than professional, Miss Langley purchased property 2 doors down from the town hall.
How many meetings have you been to?
Let me stop it a little bit here. First of all, there's no process in the hearing for objections, but I understand, and I'm objecting also. Keep it to the elements of the petition itself, if you would. I understand you have other opinions, and they do need aired, but this probably isn't the forum for it.
No,
Does that make sense?
I didn't know the process.
Okay. Let me read to you the statute that we're operating under, and that might help everybody in the room. This is the 3111-110 that's the authority for this hearing. And it talks about within 40 days after it's filed, a protest in writing under oath can be, we'll get to you in a minute. The grounds for the protest may include, but not be limited to, the failure of any portion of a petition or circulator affidavit to meet the requirements of this article. This article, when it says this article, what it's talking about is the entire initiative and referendum process within the election code. So part of what's led up to getting us here today is the protesters created the form, the town clerk approved the form, they collected signatures, those signatures were approved by the town clerk as valid, and issued a statement of sufficiency to move forward. That's what we're dealing with at this hearing, is any part of that process that you believe may be deficient. So let's stick to that as an issue.
Could you read the first sentence of that again?
Of the 3111-110,
3111-110.
within 40 days after an initiative or referendum petition is filed.
Filed? What's that mean?
Is filed. It may mean something different in this context because of the court order. Typically it means when it hits the clerk's desk, but there's a question about whether that court order actually stayed that 40-day clock from beginning. So that we can talk about procedurally.
Okay, very well.
I'm sorry, and I didn't mean to interrupt your
No,
heartfelt
thank
comments
you for
there.
providing understanding.
Yeah.
I didn't know the process. I objected not to the things of that article,
I
but
understand.
it's something that is pertaining to the content.
The content of the ordinance.
So that's why I suggested that if we can't do it in a public forum, have a debate of some type, or through the Blue Book. And this hearing was presented to me this way.
And I don't want to diffuse any opportunity for that, but I don't want to take all day dealing with that also when it's not really an element that I get to have any say over. What I would recommend is, based on whatever my ruling is after this, schedule some public events where you can have the issues, the debate
And we've talked about that.
of the merits of do we want this or do we not want it, because that's really more of what you're talking about.
We can even do it here after she's done.
And
That's fine with me. So.
the other piece of that, you mentioned a blue book. This, because it's not a Tabor issue, it doesn't go in any sort of notice. So if this were to move forward to election, there is no blue book that applies to this. That only applies to tax money related issues.
Tabor.
So anything that's Tabor.
Excuse me.
You just a second. You're welcome. After we're done today, I do think that a discussion needs to happen in a healthy context, but I want to keep it separate from this hearing because I don't have jurisdiction over it. Does that make sense?
That makes
Does
sense.
that make sense? There was a question here.
It's a question for you. Having a discussion on this after this is fine.
Mm-hmm.
But I would suggest they be evening with at least a week's notice, because this happened today because
Sure.
of the storm.
Sure.
So I would ask that it be
And
posted.
that will be something that your town clerk will handle moving forward, but I agree. That's a good
And I'll
idea.
put it on the chalkboard for you.
There you go.
Chalkboard.
Yeah.
You ought to be paying the city rent on that, because
So
that's
I-
not your property.
Really?
So I feel like I kind of cut you off midstream with your thoughts, and I'm sorry for that.
No, that's fine. I'll probably disregard some of this, I
Okay.
do believe, because it's not
Not relevant to the,
relevant to what
the
you're pertaining that
statute.
we stick to, so.
Okay. So, but please continue.
After I present that, I'd like to ask the proponents some additional questions that I haven't got from them already, if that's,
If you would ask them during their testimony time,
okay, I'll let them.
and then give them the
Oh,
chance
so I
to
can
ask you
Jake
questions.
now?
Yes.
Oh, good.
Yes.
Well, Jake, what specifically, the purpose, it's my understanding of 3111-110 hearing, is to challenge a signature in the protest by section and line number. And that's in 3111-110. And actually, if we could enter this into evidence, go ahead and give it to Jake. You
And
have a
which is
copy with
this?
him.
Oh, this is the
That is-
copy of the statute.
That is
Certainly.
the statute. And
Certainly.
make that,
Would you like to see
If you
that?
could make that D and label it for me, please.
Yes, we can do that. And that's what I just read out loud.
Maybe I misunderstood this into the full content, but I was going, the reason why this is posted on the door, and like we discussed earlier, that I wrote a protest because I disagree with your ordinance, I disagree with it from the beginning, but how I read this is that the grounds for protest may include but shall not limited to the failure of any portion of petition to meet the requirements. And I believe that an ordinance has to look out for the safety and welfare of the community, which ordinances are done for, and so I wrote an objection because I believe that you may affect the welfare of our community.
Okay.
Okay, why did you do it on the 25th of January?
Well, I really wasn't fired up until
No, I mean, what gave you that date? Regardless of fired up or not.
the posting.
Who?
The posting of the 25th was the deadline.
Who posted that?
I believe it was the town clerk on the front door.
Okay, I believe you are correct. And, all right. Was there any correction to that posting that you ever saw?
Not that I've seen.
Okay. Okay, so the town clerk, all right, very good. So you do not have any problem with any of the signatures on the petition?
Not the signatures per se.
Okay.
I question the means in which you obtained them.
Okay, as such as?
Jeff, I want to state this bluntly. That's how I am.
Please do.
We live in an ag community, and so a lot of my parables or references are to ag.
Right.
We grew up with cattle. A lot of you are familiar with cattle.
Mm-hmm.
Every summer we move bulls to pasture. And bulls know where they're going. They know exactly where they're going. They want to go there. But if you start flopping around, making a lot of noise, browbeating them to get in that trailer, usually to turn around on you and
So are you
charge
saying
you.
I browbeat people to sign that petition?
I can't say I can't prove that for sure.
Well, then,
I do have proof that you
say
signed
what you
made
know,
somebody.
Jake. Just say what you know. Did I browbeat you to sign the petition?
I did not sign the petition.
Correct. Did I browbeat you?
No, but you can't appear that way to other people. You made Josie
Bring them
feel
up.
threatened, and I will later. You made Josie feel threatened that you.
Okay, I object to that.
Now let him answer your question.
Okay.
It goes to the entire context of it.
I think you were trying to answer the question. The question was, do you see anything that meets the statute that's wrong with the petitions?
Right.
That was your. Am I understanding that correctly?
Correct.
Okay, and you began your answer by saying you felt that some of the signatures were obtained inappropriately.
Yes.
So elaborate on that if you would.
So basically, I don't know. There's nearly half a dozen signatures on the petition.
Huh?
There's nearly a half a dozen signatures on the petition that registered to vote the same day they signed.
Uh-huh.
How did you obtain those? I mean,
Internet.
Well, go vote Colorado. That was from Corey and Lango published that in the Lyman Leader. to get everybody ready because it just
No, and
happened
I
to be-
welcome that. I encourage you to do more
That's
of that.
where, from the
But
from the county clerk.
how did you persuade them?
I didn't, I just asked them if they were registered.
Okay.
And if they said no, I said, do you want to? And they say yes, then they got registered. Go vote Colorado.
All right.
.gov. Or .com, it's one of the two, I'm not sure which dot it is.
Did you appear threatening to anybody? Or I guess I should wait till you're up here to ask questions. All right.
Yeah,
Well, no,
please do.
I'll answer that, absolutely not.
We'll have occasion for that. I'll take that as an exhibit.
That'd be key.
This is D. This is D. Okay, anything else you'd like to, or you were done presenting. Any other questions from the petitioners?
I do.
Okay.
I have one. Have you read the judge's order of December the 14th?
I believe I got through most of that. You sent that to me.
I did. Could enter that, please, as
Would you like to take a look before I enter that as evidence?
No, I have a copy.
I'm going to go, I want this as evidence, so I'm going to go ahead and
Yes.
accept that as D, E.
And then may I see it back?
Oh,
Thank
yes.
you. You know, copies are expensive up there.
Yes, they are. Save a few trees.
One of the things in this order, the judge comes out and he makes specific findings and he does specific rulings. And one of the things that he stated is this case, well, the matter became before the court in connection with defendant's motion to dismiss and plaintiff's response to the motion for summary judgment. Okay, we're the defendants. Josie Hart, in particular, the plaintiff is the town of Arriba, Lincoln County, Colorado, a statutory town as defined by Title 31 of the Colorado Revised Statutes, through Josie Hart in her capacity as the Arriba town clerk. Now then, when you swore your protest, did you swear it under oath?
I believe so. I believe that says that I presented this document and she notarized that I was the one that wrote it.
Well,
And
did
I
you
signed
swear
it.
any kind of an oath? Did you make an oath that those things were true?
A formal proceeding?
It's supposed to be done over oath. Did you or didn't you do it under oath?
Yes, she asked me if I wrote the article and I typed it as my opinion. And I said, yes, this is my piece, this is my document I'm presenting.
Well, I would submit an oath as I solemnly swear to tell the truth would be an oath, but that's okay. And who notarized that?
Josie did.
Clerk Hart. Clerk Hart is also named as the plaintiff in this case, so I would submit to the court that her...
Why don't you save that for your
signature's
testimony? It's not really a question
Okay, all right.
at this
Well,
point.
so she notarized it. I'll leave that there.
Yeah.
Then did you also, in reading the order, did you notice that the judge found the petition dated approved for circulation October 7th and filed with the clerk on October 12th? The clerk did not find the petition of the 19th. The court did not find it. Excuse me. The court.
I'm not sure I understand the question. Can you
Well, in
say
other
it
words,
again?
according to the court's order, Exhibit A was found, Exhibit B was not.
Okay.
You following me?
Okay.
Okay. All right. And so that statement of sufficiency that you saw, you mentioned 6 signatures. Which petition did it deal with? Petition A? Here, you can hand it to A or B.
Yeah, and again, just as a reminder for everybody here, Exhibit A is, I'm going to generally describe this.
51 signatures.
51 signatures.
He has 6.
Jeffrey Russell Fike is the circulator, although it's also got a circulator affidavit from Beverly. And then Exhibit B is It's numbered 52 through 57, so 6 signatures circulated by the same 2 people.
What's your question?
My question was, which of those statements of sufficiency did you find from Clerk Hart? Which one did she give a statement of sufficiency on, or do you know?
I don't know for sure.
Okay.
From your understanding, it sounds like position A.
Yeah, no, it was B actually. She gave a statement of sufficiency that it was not timely on B. Is to my
Okay, just
understanding.
stick to questions. You'll have
So
a chance to
in
testify.
other words, you don't know
Yeah.
which one?
Precisely no.
Okay, cool.
Is that public
Alright.
knowledge?
It should be.
The information is available. We can look that up if it's relevant. Okay, other questions from the petitioners?
Yeah, where do you get your source that just because somebody sells 2 properties, they don't care about the town they're moving away? I mean, that's ridiculous. I don't need 2 properties, I can only live in one. If I sell one, I can live in the other.
And let's keep this related to the petition.
Okay,
To the
but
petition
he-
itself.
and
What was
He brought
the
it up.
in the context of people registering to vote the same day?
He brought it up that, that I didn't care. I mean, because I was moving, why would anybody pay any attention? Why would I send a petition around? You know?
Okay. I think that what you can ask about there is
I asked him, where do you get that information that I'm, that just because I have 2 properties on the market, I'm selling, and evidently don't care about town. That's all. I mean,
that part of his testimony isn't going to be relevant to the hearing, so I don't think your question is relevant either.
Okay. And he also brought up another irrelevant thing as far as the board. We come to town meetings, we don't get heard. That is the way we get our voice spoken. That's the only way we have been able to. Thank you for asking.
Okay.
And that is valuable conversation again to happen separate from this hearing. And I don't want anybody to think I'm diminishing the importance of these conversations, because it is important.
Okay, but since he's already brought it up and these people have heard, that's where we're lacking, is these people aren't hearing everything.
Sure. I hope that you can find a venue to get all that out before you have to decide. Okay, other questions?
Yes. Jake, if you want to look at the 40 days from the date of the filing of the petition, what would that date be? It was filed on October the 12th.
I don't know, but I'm sure you have the answer for me.
Well, I'm thinking that 30 days from October 12th would be November 12th. That goes to the time for the clerk. And then you get another 10 days from that date of filing, so 40 days. So I'm thinking it'd be November 29th. Would you agree with that?
That sounds reasonable.
Okay. That would be on petition A, or exhibit A. Now on B, the date on that filing was November the 19th. So, or October the 19th, excuse me. So I would say then 30 days would be November the 19th. Plus 10 would be November the 29th. Wouldn't you agree with that? Would be 40 days from the date it's filed. Okay, in the statute, it says 40 days within, actually, would you hand me a D, please? It says within 40 days after an initiative or referendum petition is filed, and that's when it's lodged with signatures with the clerk, a protest in writing under oath may be filed in the office of the clerk by any registered elector who resides in the municipality. That's you, setting forth specifically the grounds for such protest. The grounds for protest may include, but shall not be limited to, the failure of any portion of a petition or circulator affidavit to meet the requirements of this article. No signature may be challenged that is not identified in the protest by section and line number. The clerk shall forthwith mail a copy of such protest to the persons designated as representing the petition proponents pursuant to section 3111-106, parenthetical 2, and to the protester, together with a notice fixing a time for hearing such protest that is not less than 5 nor more than 10 days after such notice is mailed. Now, you made your protest on the 25th of January, is that right?
Yes.
Okay. From your knowledge, how would the 25th of January come into that 30 or 40 days for either petition?
From my understanding, that your ordinance, your petition for a new ordinance, the People's Ordinance, whatever,
People's Ordinance.
it was in litigation at the time, right? Was there motions filed from the clerk's office of town, as well as yourself, summons cases, requesting a judge's order on that? And I believe that is the judge's order.
I've already accepted that as an exhibit, so that's
Okay, the
part of
judge's
this record.
order was dated December 14th, is that correct? So you had 30 days onto that, that'd be January 14th, and you had more 10 days to be about January 25th. That's how I assume that they came up with the January 25th date, and so I believe that I had an opportunity to object to your ordinance. If this is the incorrect form, we're probably going to have a discussion about it later.
Where
But
did you get that information from?
from you.
No, from Clerk Hart. I didn't tell you that the judge gave any stay. Where did you get that idea from?
No, you gave me the judge's order. You
Oh,
know,
I
the
did.
one you
I did.
said-
Okay, I see
You
what
emailed
you're
it to
saying.
me.
Yeah.
In your lengthy emails, you emailed me like 17 times or 7 times that day. Jeff,
Now,
this is the stuff you sent me.
exactly.
It's the
What
stuff
my
you entered into
question is-
exhibit.
Let me clarify the question. If I understand your question, you're asking him, how do you justify this as a timely filing? Is that
Right.
right? And you have answered that
Based
it's
on the
based on
order.
the court order, and you took the 40 days forward from that court order date. Is that fair?
Yes. And I also had instruction
Here's
from the
the court
town.
order. Can you find me a stay in there of any kind that would give you that
Let
idea?
me cut that off a little bit. That is something that I will be researching as part of my findings. So because this is already in evidence, I've heard your answer as to why you believe it's timely. I'm going to research that as a legal issue
Okay.
before I make my findings.
Because in bankruptcy court, you're right, I understand that there's a stay automatic, you have to, but this was not a bankruptcy filing. And as I understand it, maybe, I know of no petition for a stay by the clerk, and I know of no stay that was granted by the judge in his order. Do you?
Not to my knowledge, but
So the idea of a stay came from where?
from your document.
No, that doesn't have any stay in it. Did it not come from Clerk Hart?
Well-
The 25th.
Well, the posting on the door suggested I had time to file
And that was posted by,
the town official.
which would be
I don't know who posted it, but I assume it to be Josie.
Clerk Hart.
Yes.
When you talk about the notice on the door, what was that? Can you describe that a little bit for me? What was that notice?
It was a notice for public objection or public protest to the People's Ordinance.
Okay.
And the last date of file would be dated January 25th.
So it was a notice of opportunity for that protest period.
Yes.
Okay. Okay. Other questions?
I do have a question. I was just wondering why.
Are you part of the protesters?
No.
Are you?
I am a signer of the petition.
I would like to hear from you then.
Okay.
Okay.
My question is that since there were so many signatures on there saying we just want it to go to election, why is it that you don't want it to go to the ballot? And
Let
it's
me
just
back up and get your name first.
Carolyn Steinzig,
Carolyn, Carolin.
Lyn.
Lyn. And your last name?
Steinsiek.
Okay. And I'm sorry I interrupted your question.
No
I'll ask that
problem.
again.
I'm just wondering why, since so many people signed, that you don't want to see it on the ballot.
To answer your question, I have never said that I do not want to see it on the ballot. I think it is detrimental to our town.
But wouldn't that then be decided and something to discuss up to the election once it's on the
And-
ballot?
And that is something outside of the realm of this hearing.
Okay.
So-
But thank you. Go ahead. I'm going to deal with that in a little bit. Let's go ahead and open the floor. Was there another?
But I don't believe that it should be immediately placed into law. I mean,
But it's not until it goes to an election.
and that's where I want to go. I want the people to decide for sure.
Okay, let's
But I
come
want
back to the-
opportunity
come back to the
for my voice
procedure
to be
here.
heard. And that's what I'm doing here. And I hope we have a public forum where I can express my interest and inform the people of the other side. So you're not just getting
Absolutely.
one side to this
Absolutely.
ordinance. That's what I'm doing here today.
But that's not what we're here for today.
Well, that's what I assumed it was here for today when I read the.
And it's understandable. You guys don't do these things often enough to be well informed about
We're all
the
new at
statutes,
this.
and that's okay. And that's okay. That's my job to kind of make it a process and make sure the right things get entered into the record. So go ahead.
You open the door, so I got a question. Well, it's doggone it up here.
I got an answer.
That's up in here, Arriba, up. Anyways, so, have you ever heard the term, are you familiar with a mandate, a voter mandate?
I don't know the correct definition of it.
Okay, have you heard of a super majority or a veto-proof majority?
I've heard of that.
What
Make
number
sure you
would that
stick. Make sure you stick to the elements of the
be?
petition.
I am.
Okay.
So do you know how many voters there were at the last election in 2014?
I'm sure you have it on the tip of your tongue.
Yeah.
Well, it was 62. Do you know what percentage? 51 as the numerator and 62 as the denominator yields a percentage of 82, I believe it is. That's on petition 1. If you add petition 2 and you use 57 as a numerator and 62 as a denominator, yields a percentage of 92%.
And what's your question?
My question is are you familiar with the term mandate or a veto-proof majority, or it's also sometimes referred to as a supermajority in government?
No, would you educate me on that? What is the
Let's
definition?
not do that today
I sure
because it
will.
has nothing to do with this hearing.
Okay.
Okay, let's take another question.
I'm a signer of that
Okay.
also, and I wanted to make it known how he got my signature.
You know, I would like to take testimony on that, but I'm going to let these people finish first.
Okay.
But I have that in mind that I would like to do, so
Great.
please don't leave.
Okay, I won't.
Okay. All right. Because that's raising some questions in my mind because of his allegation of how they were obtained. So I would like to delve into that as evidence before we're done today. Let's take a couple more and then we're going to move on to the other
I have
side.
one thing to say, that if he's to take that around right now, a big share of those people would not sign that. Knowing Mr. Pike, I
No,
would.
I
And let's save your testimony for that portion of the hearing
Okay.
also. I want to hear that, but I want to do it in the right process.
All right.
Yes.
I just think bringing that deal in about people being browbeaten to sign something they signed, we might as well bring in that the town hired an attorney to go against the people. Doesn't make,
Good point. Very good.
We're still talking about how he got
let's
signature.
deal with that at the appropriate time.
and the threat that was already eliminated in court for the restraining
Okay.
order, let's keep.
And
bringing that
some
stuff.
of these things are outside the realm of the hearing, and my job is to dissect which are, and until I hear some things, I may not know whether they're relevant. So that's why I'm allowing a pretty broad latitude here of comments, and then I'll narrow that down and determine what's relevant for under my authority, because there's definitely issues here that are bigger than today. So other questions about his evidence at the hearing?
No, Jake, do you have any fact, though, that any kind of really fact that would pertain? Now, this comes to 3111-110, which is the whole purpose of this hearing, to challenge a protest section or line number.
And it's not limited to protest section
Oh, I
or line
realize
number. I
that.
understand your question, but I'm going to go into that element a little further before we're done too. I'm sorry, I didn't mean to interrupt your question.
And I would kind of want to call your attention to 3111-110-3, where it says, every hearing shall be held before the clerk with whom such protest is filed. The clerk shall serve as a hearing officer unless some other person is designated by the legislative body as the hearing officer, as you were. And the testimony in every such hearing shall be under oath.
And I did not swear him in. We're going to take care of that right now and move forward.
Okay.
I'm going to swear you in retroactively. Is that all right with you?
That's fine with me.
Okay. Raise your right hand. Do you solemnly swear that the testimony you have given and are about to give in the future will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. So just for the record, everything he testified to and also every exhibit that I acknowledged is under oath. Thank you for keeping me in line.
I'll try.
Oh, you will.
All right.
Would you like me to go through individual signatures for you, Jeff? I didn't object to that, but I can for you if that would help clear things up.
Mr. Mitchell, what I think I would like to do is give the petitioners their time to do their presentation, and then at the conclusion of that, I want to delve into individual signatures a little more for my own benefit. So at that point, if you have either questions about signatures or responses to signatures, I want to hear it.
Okay.
Okay, but let me get through the
I just
other
have one
elements
more
of this.
question.
Oh, yes.
So you did not do an oath like you just took when you made the complaint? Is that
Nothing, not
correct?
official.
Okay, good. Thank you.
All right, Mr. Fike.
Yep.
The floor is yours.
Oh, hot diggity dog. All right. First of all, as was found in Exhibit D of this, no, wait a minute. That would be Exhibit E of this hearing. D is the statute, but E, obviously, D's right there. Where's E get off to?
E is the court order that I have right here.
Yeah, okay. Let's go over this whole thing right quick from the beginning. So,
Are you gonna swear him in?
huh? Oh,
Yes, let's swear you
Well,
in.
actually, Bev, do you want to go first?
No, go ahead.
Okay.
And you're welcome to call her as a witness,
Okay.
if you like, after your opening statements. Do you solemnly swear, subject to the penalties of perjury, that everything you're about to say will be the truth, the whole truth, and nothing but the truth?
I do.
All right.
Okay, so I created what's now known as the People's Ordinance. I came up with it after careful thought, lots of prayer, reading our Constitution, going back over it, going from the law of Genesis all the way through the Supreme Court. And what I found out was that we already have the right to govern ourselves, but it's somehow been usurped by some of these bizarre actions of governments and boards overstepping their authorities, especially in municipalities. Now, the thing that you and I are used to is corporate boards, Jake, which is different than a municipal board. And so efficiencies on a corporate side are absolutely imperative. But on a government side, they're not, because we have a Bill of Rights. We have all these things. We have the right to free speech. We have the right to keep and bear arms. We have the right not to incriminate ourselves. We have the right against unreasonable search and seizures. So we have these rights. So all of that was put in to the language of the People's Ordinance. May I see A, please? Please. And let me read it to you, because when I circulated this, some people, right quick, they all got asked the same thing. And here's the question. Shall the people of the town of Arriba vote on all new ordinances or the modification of an existing Town of Arriba ordinance? Yes or no is the question. Okay. The whole thing, which I left with Ms. Childs and Mr. Childs, a copy of this for their reading, goes as follows. I'm going to skip the "it's against the law to commit fraud," we all know that, and get to the title, which I just read. Shall the people of the Town of Arriba vote on all new ordinances or the modification of an existing Town of Arriba ordinance? Here's the summary. Now, the summary was prepared by Clerk Hart in conjunction with Town Attorney Stan Kimball. Is that correct, Josie?
She's not
listening.
part of the hearing.
Okay. The proposed initiated ordinance will require that no ordinance as adopted by the Town Board of the Town of Arriba, Lincoln County, Colorado, which may be adopted after the passage of this initiated ordinance, or any modification to any existing Town of Arriba ordinance sought to be made after the passage of this initiated ordinance shall not be enforceable until such time as the ordinance or modification of an existing ordinance is first placed before the registered electors of the Town of Arriba at the next regular election of the town, generally held on the first Tuesday of April, in even-numbered years, or specially held election for such purpose. And the ordinance is approved by the registered electors of the Town of Arriba. Now that's what the clerk, and that's the summary. They get to write that as part of the process, and I believe you'll find that in 3111-103, I think, or 104, one of those. But anyway, so the proponents are me and Beverly, and here's what the ordinance says, and it's now known as the People's Ordinance because the clerk and the town board refuse to put this on the agenda. They've gone so far as to make false accusation. They've taken it to the court in an untimely manner because, see, the issue with the court is this, and it came from Clerk Hart's quoting of Aspen v. Wagner. There must exist an ordinance for the court to rule on. And so it was not ripe fruit yet for the judge, but the judge took it anyway because if he didn't, we would have got nowhere with it. And he realized the constitutionality of the matter. So that's why he took, but he just ruled on specific parts of it till it gets all the way through, which it's there now, or it will be shortly. But this is part of the process. So anyway, an ordinance requiring that all new Town of Arriba ordinances be brought to a general public vote at the next regular or special election for the Town of Arriba, Lincoln County, Colorado. Whereas the people of the Town of Arriba, Lincoln County, Colorado, pursuant to the Constitution of the State of Colorado, Section 1, Article 2, in order to assert our rights, acknowledge our duties, and proclaim the principles. This is a quote, by the way. Quote, direct quote. In order to assert our rights, acknowledge our duties, and proclaim the principles upon which our government is founded, we declare all political power is vested in and derived from the people. All government of right originates from the people, is founded upon their will only, and is instituted solely for the good of the whole. It is the intent of this ordinance to preserve the right granted by the Constitution, State of Colorado, for the people to govern themselves, which is hereby affirmed as a right reserved by the people of the Town of Arriba. Now therefore, be it ordained by the qualified electors of the Town of Arriba, Lincoln County, Colorado, Section 1, that all new Town of Arriba ordinances or the modifications of an existing Town of Arriba ordinance be brought to a general public vote of qualified Arriba electors at the next regular or special election for the Town of Arriba, Lincoln County, Colorado. 2. all new town of Arriba ordinances or the modifications of an existing ordinance. Notice ordinance, only word in there, ordinance. Ordinances are laws that govern you, and it has nothing to do with resolutions and the day-to-day operation of the town. Just ordinances. Purely legislative. Shall be brought to a public vote at the next regularly scheduled general election historically held in even-numbered years. In the event a special election is deemed required, it shall be held as prescribed by Colorado law. Immediately upon its passage, this ordinance shall be recorded in the town of Arriba Book of Ordinances, kept for that purpose, authenticated by the signature of the mayor and clerk, and shall be published as required by law, and I put this in there, and additionally published to the town of Arriba website. Only thing published on there now is those things that they want to beat us over the head with, specifically Ordinance 112, which is the cleanup ordinance, and Ordinance 128, I think, where they want you to pay for your sewer even if it's not connected. So those are the only two ordinances, to my knowledge, published, other than the proposed marijuana things on there, but it's not under ordinances. So that'll be published there, and it was adopted and approved blank day of blank year. And as of this time, the mayor and clerk have refused us to get on the agenda, refused us to speak, and just act like it doesn't exist, which is why it got the name, the People's Ordinance, Jake, because I couldn't get a damn number to put on the thing. So I named it, published it in the paper. The signatures were all timely done. Some people, Beverly, myself, Carolyn, jumped right on it. The two Childses, they were left with a copy of the first 2 pages that contain the ordinance and the summary for them to ponder. Did they want to do it or not? What this does is it preserves ex post facto, the doctrine of ex post facto. So it disturbs nothing in the past. It preserves the initiative process, which is this petition, where you can do initiative 2 all the way up through the process. It preserves the referendum process as well, when the board makes legislation all the way through, okay? The difference is whether I make an ordinance or you, let's say you're the board, okay? You make it, it's going to go to the people. Now that's going to imply a couple of things. So you were right, Jake, on a couple of things. Number one is, there will not be any legislative casserole ever. Why? Because the ballot laws in Colorado call specifically for one item. Case in point, one of the issues that brought this up was the board trying to make an ordinance or modify one that was titled mobile homes. And then they tacked into that same ordinance RVs. And then they tacked on the end of that non-conforming structures. There'll be none of that ever in the future. It has to be one item at a time. So they could add 3. Now they can have 3 ordinances. They could have one for mobile homes, it would come to a ballot, one for RVs, and one for non-conforming structures, whatever that is. That's pretty vague and ambiguous.
I'm going to catch you off a little bit there.
Yep.
It sounds to me like we're going into the elements of good and bad argument about the
Well, I'm going into what it does.
But talk about the petition. Talk about the petition.
I'm talking about what
And
the petition
specifically, the structural elements of the petition and the protest to which it's made.
I'm
now, let me
on the money, I think,
let me be clear
it brings
that
it to the ballot, and the ballot is what I was just speaking about.
and I understand that, and again, that's a debate for another time. So, just to be clear, what I have sorted through so far in Mr. Mitchell's presentation, I will be eliminating from my decision anything that is, we want this or we don't want it. That's not my purview. What I have heard him talk about is questioning how the signatures were obtained, which we're still going to deal with. I've heard him talk about we've talked about the timing collectively, which I will consider. So deal with anything of that nature that you want me to hear that I have not heard already.
Okay, so as I said, I took it around and got people's signature on it, explained it to them, and I asked everybody the following question as well. And that question was, do you see any downside of this? Does anybody see any downside of it? And the only answers to that question that I got was, well, what if we had a town emergency or something? And the answer that I gave there was, well, that would be done by a resolution of the board anyways. That's how we handle our finance. It has nothing to do with this. Separate issue. This is just ordinances. So that's all I have on signatures. Actually, let me ask
Diane.
Would I get first opportunity?
Ms. Childs.
I'm going to let him present any testimony and witnesses that he would like first. But with each of those witnesses, you can ask them questions. So if you have questions right now for Mr. Fike, we can do that. Or if you'd like to wait until he's done with calling his witnesses, either way.
However you want.
Either way, we can do that. If you feel it's, yeah, you can. I'm being pretty informal here.
Go ahead, Jay.
Is that all right, Diane?
Yeah.
Okay. So, are you asking of Mr. Fike or somebody else?
If I may go first.
Yes. Yes.
Butted right in front of Diane.
Okay. You're fine.
You mentioned that the purpose of this ordinance is to change something that's already broken, that you want to fix it. Now you want, well, that's the purpose of an ordinance, is to develop something.
It's going to give you the right to vote and know. The ordinance does two things. Lets you know about it, lets you vote on it.
But the processes already exist for that already. And you've used them, like you mentioned in the mobile home thing. I believe in the September meeting, when you objected at a public hearing to that ordinance, and you stopped it. You expressed your concerns. You brought light to some other issues that the board wasn't thinking of all the time. But I'm saying there's already processes available for this ordinance to take place, so we don't need to change something that way.
Well, Jake, you make an excellent point, because
It is an excellent point, but it's not a matter for this hearing.
Okay.
I'm sorry. I hate to keep reining you back
Save
in.
it for after.
I hate to keep reining you back in, and I don't want to discourage good conversation, but I want you to do it in a way that's going to be productive.
Yes, ma'am.
Okay. Other questions about his statement, opening statement?
Yes, let me think of one that relates to what you...
to the issue of the hearing.
Better give him 110. Where is that? There.
And if you want a chance to think through your questions a little more, we can proceed
ahead,
with
Diane.
witnesses
Yeah.
and then come back to you.
So, when, didn't I give you a copy?
Bring your witness forward so I can swear her in.
Oh, yeah. Come on up here, would you, Diane?
And spell your name for me.
Diane, D-I-A-N-E,
Uh-huh.
Child, C-H-I-L-D.
Okay.
You want mine?
Do you solemnly swear, subject to the penalties of perjury, that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. You are welcome to speak on your own, or if Mr. Fox would like to ask you questions to draw out your testimony, your choice.
No.
Okay.
You want me to just tell how this happened? How I
What?
signed?
I was
What do
just
you want me
gonna,
to-
yeah, well,
Okay.
tell us about it.
The first time we were going around town, if you remember, we were with Kay, which she could hardly hear. You know that. She has a problem with her hearing. Okay,
listens
you
well,
asked us. Oh, yeah, right. Okay. You asked for our signatures on these. And Ronnie asked you if you had copies for us. And you said, no, not right now. So that was fine. And we said we would not sign anything that we didn't read first. Okay, Kay went ahead and signed it. She texted me afterward. She wanted to know why we didn't sign it.
Did you bring
Because
that
she didn't
text with you?
understand.
Did you bring that text with you?
On my phone? No, sir, I did not.
Oh,
It
just
was-
wondered.
It was a text, and I don't save them for 6 months.
I hate them too.
No, I don't hate him, but anyway, okay, so we thought the thing was done. You know, we thought that he would leave us alone because it's just been one thing after the other. And he knows that.
Wait a minute, hold on.
Let her
What
finish.
time frame are you talking about? You're talking about back in October, right?
Right, when you're walking around town getting people's signature without copies to give them. Okay.
Let
Then-
me ask you a question before you go. You mentioned Kay. Who is Kay that you're talking about?
Willoughby.
Willoughby?
Yes.
Willaby?
Yeah.
All right, continue.
Yes. Go ahead. Or
Yes, you can go ahead.
Anyway, so then he shows up on my door, and I'm by myself. And normally, when I have a visitor, I ask them in, and what do you want to drink and everything. But I did not ask him in. I just did not ask him in. I don't want anything to do with it. So then he stood there, and he wanted me to sign this. So I finally did let you in. And he did not leave. And finally, Rodney, and I did go ahead and sign it. I thought, just to get him out of here.
Whoa.
But I did ask you that day. I asked you that day, does this mean that the board has to vote, or the people have to vote on everything?
Easy now, easy, relax.
Yeah,
Don't have a heart attack.
I've been waiting
So,
for this for a long
you're
time.
saying that I did not leave a copy of it with you and Rodney?
You left a copy of it.
When?
Right, that day.
Before you signed it?
Right. No, I signed it. I did not read it. But it didn't
Really?
matter because I was okay with signing
Can
it.
I treat her as a hostile witness?
No.
Okay.
Yeah, what does that mean? He
No.
gets his gun out and shoots me.
No.
But Gerald and Carolyn, I do want you to know how
you'll have a chance in a moment. You'll have a chance. Let me finish with the elements
Okay.
of what you're saying, and I might have some questions for you also.
That's fine.
So, am I hearing you say that you? Let me back up. When you understood the nature of the petition and what the ordinance said, were you supportive of signing that petition?
I wanted him out of my kitchen. I'm sorry.
Were you supportive of the elements of the petition?
I felt it was okay, but I asked him that day, does this mean? And he said, no, that does not mean the board, that we have to vote on everything. Because I felt it would, I'm smart enough to know that would hold up the board on having all of this happen.
Okay.
So, I mean, I
So
don't know what dress is, but
Sure.
that's what I felt that day.
Okay.
Intimidation.
Okay.
Go ahead.
Do you have any
Evelyn.
other? Let's finish with Mr. Fike, and then I'll come to you. Do you have any more questions for her?
I do. So it was your testimony that I did not leave a copy of that with you to look at before you
You left
signed
a copy of it. In fact, I think you brought it by for Rodney, and I read it.
it? Okay, good.
And that's why I asked you that day before I signed it. Do you remember that? I asked you that. No.
Ask me what specifically?
I asked you if that meant that the people had to vote on every little thing that came up, and that would have the board. So that would
Ordinances
totally.
only.
Yes.
Ordinances only.
Okay.
All right. I
You're
think.
smarter.
Well, I think I understand. I understand
Right.
your statement, and let's go to your question as a petitioner.
Okay, I just want you to know, I was sitting outside in his truck when he did get the signatures. And it was a very cordial thing, walked in, spent some time and walked out comfortably.
You were out there at my house,
Yes, I was sitting in
and
the
he
truck
cordially walked in
waiting.
and out.
Yes, yes.
Let me ask you a question. I'm looking to see which. I'm looking to see which petition you signed.
Very last one.
And after I thought, I should not have done that. I wish mostly
Okay.
because I don't want to support him.
Okay.
Yeah, I support him, but what about the ordinance?
Is this?
No, I said if it's going to stop the...
Let's cut that conversation now. I'm sorry, I'm not finding you. You might be on the other
On
petition.
B at the
On
last
B at the
signature.
last. All right.
I think she's the last, near to it.
Diane Child, there you are. Okay, so when you were presented with the signature, it sounds like, am I understanding correctly, that it was Mr. Fike at your door asking you
The
to sign?
first time it was on the street. He was
Okay,
asking.
okay.
We said we wouldn't do it.
But it was him that asked you to sign
Yes,
it? Okay.
right.
And then Was Beverly present at all?
No, I didn't even know she
And
was
you're-
outside.
I was in the truck.
Okay, that's fine. Okay, that's what I wanted to know. Other questions, and we can open it for others if we have more.
I think you done.
Okay.
There's a question in the back. Let me
Yeah, well, that's
catch
my
that.
I have one thing to say.
Okay.
Jeff does not represent the...
Oh, let's get him sworn in, let's get him sworn in.
Yeah, let's.
He doesn't represent
Let's get
the
him
people.
sworn.
If you feel like there's something you need to say before we're done, I'll bring you up and swear you in. If I feel there's something
Okay.
that I need to hear from you, but don't lose your thought.
Okay.
I'd like
Okay.
to call Mr. Giles.
He wants to
And
go
if you'd like to call him, you can do that now.
Come on up, Mr. Giles.
Yeah, I know.
And tell me your first name.
Rothschild,
Rod, R-O-D?
R-O-D,
R-O-D.
C-H-I-L-D.
All right. Do you solemnly swear, subject to the penalty of perjury, that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. You may respond to questions, or you may present your own testimony.
Well, I just wanted to make a
You can
statement.
have a seat.
That I told Jeff I didn't dislike him, but I don't approve of him, what he's doing, and he does not represent the town of Arriba. He's on his own.
That's your
I
team.
talked to a lot of people in town. They don't like what he's doing. It causes a lot of problems. Nobody needs it. I don't care about the ordinances or the whatever numbers, make no difference to me. I lived here for 6 years, a nice little place. I like the no complaints. All of a sudden, it's a big hassle. And not needed. And I would not have signed that. I talked to several other people, would not have signed that. You
I object to the hearsay and speak for himself.
There is no hearsay in this.
You come up with
hearing.
it.
Let me bring it back to subject though.
Okay.
I'll let you finish with your question first, and then I have a question for you.
Okay.
Go ahead and finish your question.
Okay. When I first offered it to you, you wanted to read it, and I didn't have a copy with me.
Right,
Is that
right. Brought me over 2 pages of it. Right. Not the whole thing,
Exactly. Well, everything but the signature pages. But, right?
Yeah, I don't know what was on the rest of it, but that wasn't.
Yeah, it's the first two. Here, take a look.
Yeah.
Present. This is exhibit B.
Yeah, it did.
That's the one you signed.
Yeah.
So I gave you that page, right? And that page, page 2.
No, I don't think you did. Maybe you did.
But
too.
not page 3.
No.
You just have these 2 pages.
Right.
Good, okay. That's all.
You know, the
And did
original
you
thing
sign it?
sounded okay in the first place, but when I got to know how much trouble you're causing, I would not have signed it, and a lot of people would not have.
What trouble are you talking about? Be
Everything you're
specific.
doing here is all,
Be specific.
Josie Hart, that's ridiculous.
Excuse me?
You're attacking her is ridiculous.
Attacking me.
Let's
I
bring it back to the
object.
elements of the
And I want that noted
hearing.
for the record,
Right,
to
right.
bring
He's-
into 15C,
Right.
16C1.
That has no place in this hearing, so we're not going to talk
Okay,
about
okay,
that.
okay.
But-
Anyway, I wish I wouldn't have signed it.
So I have a question for. Or did you have a question
Go ahead.
first? I see that you signed it, petition B. That's marked Exhibit B. When you signed it, was Beverly present anywhere?
In the
I never
when you
saw
signed
Beverly.
it?
I was in the truck.
Okay.
Oh, you was out in the truck, okay. I didn't go out the truck.
And it was Jeff that had the petition in his hand for you to sign. Is that
Yeah,
right?
I don't know if Beverly's got to do with it.
Okay. She's acknowledged that she is a circulator of the petition. Is why I'm asking.
Yeah, I didn't know she was in there, but she was in the truck, that's it.
Okay.
Okay, one other question
Mm-hmm.
for you. Oh, I'm sorry.
Go ahead.
Bev. Do you see my signature on here, or my name on there anywhere? What's my title?
Well, I'm glad you don't have a title as far as the town is concerned.
What's that word about my name? It's a big one with a P.
What is he talking about?
Right.
Proponent.
Oh, proponent,
Do you know
I
what that
guess.
means?
No, not sure.
Do you know what that word means?
No, not sure.
Okay, a proponent is someone that represents that petition and the people that have signed off on that
Yeah, well, I
petition.
feel bad about that, because
So
I
does
talked to
that
several
make
people
me a
without signing.
representative of the town of Arriba, in your mind?
Do I?
Does that make me a representative of the people that signed
Well,
these two
you know,
petitions?
On this petition only, and I don't wish they had signed it.
And this one? Well, you might wish that.
No, I know, but I can't, if I can't take that back, I can't take it back, but
Did I force you to sign?
you don't represent the town of Arriba. Because nobody's saying, everybody that I talk to thinks you're a troublemaker, which you are, so. That's what
Everybody?
we said.
Okay,
Like who?
let's go on to the next
Like
question.
who? Mr. Childs, like whom?
We'll let Beverly go first, and we'll come back to
Actually,
you.
since you've been here,
Give some
tell me
names,
one
like
thing that
whom?
you've actually.
Okay, let's cut this conversation off here. It's not relevant to the
Go ahead and
hearing.
sit down, Mr. Childs. May I have a 5 minute, or a 1 minute water? I
Sure,
need to get a splash.
sure. Let's take just a little stretch break. We can stand up for the stretch.
Okay, all right, I'm ready.
Let's wait till we're back on the record. We've given.
Hey, there's still no light bulb in the town bathroom. How about that?
The light switch is inside to the left.
Rodney, I think there were still some questions for you.
Rodney,
What is it?
I think there's still some questions for you. You
Oh,
might want to
okay.
come back up. I cut you off and then I make you come
No,
back.
no,
See
that's
how
fine.
I am?
Oh.
Okay. All right, let's take questions,
Okay.
Ms. Langston.
Okay, in regards to the petition, days before, I was approached by you, and you wanted to use Ordinance for meetings.
You know, I mentioned that, I said.
Yeah,
hey,
because you were gonna have to pay for a permit for your RV over there.
You know,
And two, okay, is that not true?
What
No,
was
that's
your
misleading.
question? What was your question?
That's misleading.
That's where the petition
How does-
is considered. We were doing it with the best intentions of helping the people have a say as to what happened. And I am just reminding him how he was over at Ordinance, okay? And asking
What is
him-
your question?
asking him if he didn't think there was a reason for signing that.
You know, I did see where it sounded reasonable in the first place,
Okay, that's all, that's all.
but
Wait a
after
minute,
all the
let me
trouble that's
explain.
been over this whole thing, I think the whole thing's ridiculous, but yeah, whatever.
But this isn't caused by one particular person.
Oh, yeah?
Yeah.
It wasn't that way before.
Okay,
No,
let's stick to
Before Jeff
questions.
got here, it wasn't
Go
like that.
ahead, Mr. Mitchell.
Okay, go ahead.
Okay.
Okay, there's also an ordinance about the sewer, okay, being paid. If you use it or not, you didn't pay sewer charges,
I do pay
did
sewer.
you?
Let's
I pay sewer
let's
tax.
I mean, the beginning.
let's cut this to just the elements
Okay,
of this
but
hearing.
this is why we with good intentions.
And I
started.
understand that, and I hope that you continue this conversation beyond today, so that you can.
See,
Learn
that's
those
where
things.
we're at a standstill
I know.
because
I know it.
of the way things are working.
Okay, Mr. Mitchell.
Rod, as a matter of fact, you did sign it, right?
I did sign it, and
Yeah.
I say I wish I wouldn't have because of the way it's going.
But your general understanding of any petition is that you're agreeing that it needs to be considered. Is that correct for the
Yeah,
general understanding for a
once the
petition?
people vote on things before you pass it, that sounds reasonable.
But you did not want this to become an automatic law if you signed it, is that correct?
No, I just didn't, I didn't sign it, I just didn't get rid of it myself.
Because at the top of this page, it says, "We, the undersigned, the town of Arriba registered voters, understand to agree the petition require be added to the general ballot." You're not saying that you want it to be a law automatically, you want it to be considered, and that's why you signed it.
Yeah, that's fine too, I
So-
understand that part.
It's not necessarily that you totally agree with this, but you think the town people should actually think about this
Right,
and see if the town wants it as a whole and not just 50-some signatures, of which we question
that'd be fine.
the validity of.
yeah, once the town should be able to.
So
think about
for
it.
my own clarification, I want to know if you felt like you understood what you were signing when you signed it.
Well,
And not necessarily getting
Well,
into the
basically-
content or the merits of the ordinance, but did you understand
I
what
don't
you
know
were
what the rest of it said, but I mean, whatever he gave me here, a couple of pages of it.
Okay.
Basically, it looked to me like it said the town, people should be able to vote on something before the town passes it. That sounds pretty simple.
Okay.
But if it's more complicated than that, I didn't understand it, no.
Okay. All right. I think that's all then for you.
Okay.
Thank you. You can sit down and we'll go for the next witness.
All right, thank you.
Thank you.
Can I call Harvey Duncombe,
You
please?
can.
Harvey?
Spell that last name for me.
D-U-N-C-U-M, I believe, isn't it, Harvey?
Will you spell your last name for me?
D-U-M.
M?
C-U-M.
C-U-M, Harvey.
Yes.
Alrighty. Do you solemnly swear, subject to the penalties of perjury, that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Alright.
Harvey, you didn't sign the petition, did you?
Nope.
But I come ask you, didn't I?
Yep.
And when I asked you, shall we vote on new ordinances or changes to existing ordinances, yes or no, you said no. And I asked you why. Remember that?
Not really, not word for word.
Okay. Do you recall what you said?
I said I'm not signing any ordinances for anybody.
Well, I remember you saying, when I asked you why, you said because we had representative government. Do you remember that?
Yeah, we got town board.
Do you remember me asking you how that was working out for you in Washington?
Nope.
Okay. All right, I got no further questions.
Harvey, I got a
Mr.
question
Mitchell?
for you. You've served on the town board a long time, haven't you?
Yeah.
Not currently, but you have in the past. You paid your dues. And every so often, a term lasts how many years? 4, is that correct? And then we have an election process, right? So if somebody has a disagreement with what's going on with the board, everybody has an opportunity to elect a new person to represent them better, is that correct? And we're at that point in this juncture in our time right now is to elect a new board if so need be.
Yes.
Thank you.
Okay. I think we're done with you.
Okay.
Any other witnesses?
Yeah?
Sure.
Is it my turn?
It's his choice here how he wants to present the
Well, I
evidence.
mean,
so-
I'm the other.
Sure, you're welcome to
Okay.
come make a statement or answer
I
questions.
want to call Clerk Hart after she's done.
Okay. Do you solemnly swear, subject to the penalties of perjury, that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes. Thank you.
Okay. I was not even going to dignify this meeting with a waste of any more of my time. But
I'm glad you stayed.
I
Thank
am
you.
too, because I feel we're on the right track as long as we have somebody to listen. Okay, we did this petition with the best intentions for the town, and that's that things wouldn't change just because the town board decided, which we haven't had any say for months. And if the petition had been taken care of with the same vengeance that the town clerk and board have spent retaliating in the past months with their restraining orders that were never effectively placed, this meeting would not be necessary. The proof is in the signatures and the compliance dates. That's all I have to say.
I got a question for you, Beverly.
Questions?
How long you lived in Arriba, Colorado?
11 years.
11 years. And have you ever heard the term the Arriba Mafia?
Not quite to the Arriba Mafia, but as far as the town board picking and choosing what they do and to who, it's not of equal value to everybody. Not everybody's treated equally. Thus comes the petition.
I see.
And
Okay,
it's
so
been
that's,
that way for 7 years that the board has been on. The board does not, we are their constituents. We pay our taxes. We voted them in to be heard. And it's fell on deaf ears no matter what we do.
so they don't represent you in your...
No.
No.
They just hear our 5 minutes and ignore us and go to the next. For example, the ex-town mayor, Ted
Can
Grundman.
we bring it back to the elements of the petition?
Yes, this
Move
is.
right straight to
Okay.
it.
Ted Grundmeyer, the ex-town mayor of this city, was at a town meeting, and he said he told the board if they have, he said I didn't sign the petition, but if they have that many signatures, it's a mandate. And it fell on deaf ears once again, and they moved on to the next person for their 5 minutes.
Was it there in the November 2015 meeting?
I don't recall, but I do know there was a town meeting. It's in the it should be in the minutes.
Let me ask you a question about the concept of the mandate has come up a couple of times. How do you define a mandate? What do you see as that?
That it should be put into effect immediately upon her checking out, approving the...
And you realize that's not part of the process. That's not what's required in the process.
Okay,
What
so...
is?
Yeah, well,
exactly what we're doing today. And then the next step, if my ruling is that the petition is valid to move forward, the next step will be for the board to consider whether to accept it immediately or to move to an election.
well, the timely compliance...
And that's something I will be looking at.
Okay, the timely compliance
Yeah.
is the cause of all the friction.
Okay, so I'm going to make a note that you have an issue with the timing as well, because that is something I'm going to research.
Like I said, if they took the petition with a vengeance also.
Okay.
Sure.
You've recently told me that you participated in the town board, is that correct?
I was on the town board when I first got here.
And you participated, you're an active member of our community, is that correct?
Well,
You buy properties, you fix them up, you sell them, you go to public hearings, you're active in this community. is that-
I like to be, but if you're not being heard, everybody's wasting their time.
But we've already experienced the processes, and you've experienced them personally firsthand, right?
Yes.
You've experienced public hearings to express your voice?
public hearings.
Yeah, you've done
This is the first public hearing that we've actually been able to talk. This is in front of
And this is
somebody
not a
with-
public hearing.
Well,
Just for
I mean,
record.
in front of somebody that it's justified with.
It's
Our
open to the
town board
public.
has lost the respect for the public.
But you've also participated in elections, is that correct, to get on the town board?
Yes, and I also, once again, if you look at a paper that Ms. Hart gave to Jeff Fight, Kay Willoughby had 31 votes, Alex Flores had 29. Somebody crossed off Kay Willoughby's 31 and put it up for Alex Flores, and Alex Flores 29 down to Kay Willoughby's. This is what, and they didn't initial it. Now, if you're proud of what you're doing, you would initial something like
I
that,
would
wouldn't
ask
you?
that be entered into evidence.
And that's what I'm saying.
Okay, let me get a
We
little
have the
background
wrong
on
mayor.
this.
As far as I'm concerned.
And we're gonna have an option to do that, because we have an election coming up in 2 years where we can elect a new mayor. All I'm saying.
Right, and I understand.
What I'm saying is that we have a process
Yes,
already
we have a
developed that
process,
works,
but-
that works in the western United States
Yes.
perfectly. Why do we need to develop new rules to decide how we're
It's
gonna
not
make
new
them?
rules.
Your ordinance is new, is that correct?
The ordinance is new,
Yeah.
but to handle it a different way, because we have been ousted. We're not being heard. They're doing what they want. They're treating Mr. Rodney Childs different than they treat me. Because they don't like me.
I'm okay with it.
They like with Rodney because he's quiet. He doesn't want
Okay,
to.
let me cut you off here. What I've been handed here is titled Town of Arriba Election April 1, 2014 Plan of Action, and it talks about some candidate petitions and clerk at the time Chris Snyder. I'm not going to accept this as evidence because
Do
it
you
has
have
nothing to do
do
with
you have
this
the paper
hearing.
that Mrs. Hart gave you with those votings that are crossed out?
I do, actually. Why don't you ask her for it?
Let's not even go into that because I
Okay,
have
well-
no jurisdiction over
Okay,
that.
all right.
Election
That's what these
Does it
people
have
need
to
to
do
know.
with this election or the
It
past
does.
election? Then I should deal with it separately,
Yeah.
not at
We
this
definitely
hearing.
need that, and we need it.
All right,
We need
can I
it
wrap up?
supervised.
You may.
Okay. Jake, you got any more questions for me? Well, let me summarize and then you can, yeah, okay, fair enough.
That was.
Wait a minute. I have questions for you. I'm sorry.
Okay.
I'm going to call you
I'm
back.
sorry,
I'm
I'm still up there.
You're still up here?
Okay.
gonna run and grab my coffee.
Okay. On both the sets of petitions, Exhibit A and Exhibit B, they had circulators, affidavits signed by Jeffrey Russell Fike and by you as a circulator. Tell me your involvement, what you witnessed with each of the signatures, where you were when they were signed, where the petitions were they in your possession, or were they in Jeff's possession? Tell me a little bit about that.
No, Jeff, what? Okay. I wouldn't have spent the time that Mr. Fike did to do it. He did it right, as far as I'm concerned. He needed a proponent, and he asked if I would be, and I was. I saw him, like I said, I was out inside the truck when he went into Rodney's house. I was driving by when he was next door talking to my neighbors, and Maria.
Who's your neighbors?
Candy, I don't know her last name. I'm sorry.
If it's on the petition, I will find it.
Candy. And Justin just moved.
Candy and
Justin is a renter from Texas.
Okay.
So they were talking to him while he was going around, and he would call me and say, I've gotten these signatures. I'm gonna tell you, I didn't have enough faith in these people in the town, the older people that have been here for so long, to sign anything. I didn't think he stood a chance, but yet I signed on because here's somebody that moved to this town with no intentions of fighting a battle after coming here, but he saw what was going on with his neighbors.
So my question is specific to what you witnessed in terms of the signatures.
I just witnessed that he was out talking to people, and then we would speak of who he got, and I took the initiative to, I can't remember which ones, to be quite honest with you.
Can you tell me of the signers on both petitions, which one? I'm looking for something where you had the petition in your hand and said, "Will you sign this petition?"
Oh, okay.
Did that occur
Yes.
through this, or were you just in the car?
Let's see. Danette. Danette.
Yeah,
Okay. I got her signature.
yeah. I got most of them. You got some.
Yes. I'm trying to.
So, am I understanding correctly that both separate petition packets were given to signers by different people at different times, being between you and Jeff?
Yes. Okay.
One or the other of us had
Yeah.
control of
Because
the
there's some on this one too. Because I've been here, and so I just, but hey, I think he was going down the right road, and that's why I went. But let me find another one that I can. On this one,
No, I'll do
I have to read through them. Sorry.
That's fine.
Okay. I wasn't. Now, see, I was headed over I went over to Johnson's and rang the doorbell, and they weren't home when I went. Okay? And there's another one I'm looking for, because I absolutely.
Hope you're getting paid by that.
No. Actually, I'm doing this for free.
Bless you, my dear.
I'm not doing the rest of the election for free. This was just this was my bonus.
I'm trying to find her
Wow.
name.
I don't necessarily need to know the name, but you had at least 2 people then that you personally witnessed their signature.
Well, I went, like, I would go to some that that I would say, okay, how about that? And he'd say, well, why don't you go over there?
Okay.
And I went over to, like I said, I went over to the, what's the house?
Which one?
That's catty corner from the Pepto-Bismol house.
Oh, yeah, next door to Bobby Rush's to the east.
Yes, it's
Purple House.
it's a purple house.
It is.
It's Jack and Sharon.
Okay, see, and I went over there, but they weren't there.
They were.
So I had to have, and I signed the top. Okay, so, and Mike Shirley.
I think you might have got, no, I got mine. Or no, or you got, I don't know, one of the two of us.
You see, it's hard to remember.
Okay.
Yeah, but one of the two of us.
But I knew Mike Shirley better than he did.
All right. That answers my question. Thank you. All right. And now we were
Colin
moving to
Clerkhart
the.
along with.
Okay, you done with me?
Yeah, we're done with you.
Along with all of her records of, that she posted regarding the statement of sufficiencies
Okay.
and the notices of this hearing, very
Bring you
notices.
out. And if you would bring your statement of sufficiency and whatever you had posted on.
Everything she's posted at the post office, including the corrections.
Today, so, yeah, but. Mr. Price called me a witness.
Needs to go to the ballot.
She's gonna get those records, and bring them out.
It's me. And it was story. But that's up to her. Well, actually, no, she didn't get to do
Do you have witnesses after Josie?
No.
Okay.
No, then we'll go ahead and rest. I don't think.
While Josie's doing that, I think she left. There was another petition
Yeah.
signer that wanted to say something. Is she coming back?
No.
Oh,
I
okay.
mean, this is, 2 hours.
I told everybody it'd be short, didn't I?
Yeah, well,
That's all right.
never been
Nothing's
to
ever short and
Arriba.
sweet anymore.
It's okay. It's okay. Take the time to do it. Do it right.
But he,
If she's still here, I would like to hear from her.
Yeah, I gotta go.
And I can do that right now and not make her wait.
is Carolyn still out there?
Got the cows fed, Rob? Huh? Got the cows fed?
I don't know.
He was really nice to talk to you.
Anybody if I want to go or not.
Please have the time.
I told my cigarette's gonna kill him off here.
They're coming back.
Oh, good. I'll call her now so to not keep her waiting.
Car out.
Yeah. We're gonna go out of order a little bit. Did you find what you needed? I think so. And that's what was on the door, right? Okay. Well, now we're waiting on other people.
You had to, I didn't see the inside of it. You did a nice job on that building over there. I didn't see the inside of
Thank you very much.
it. You do a nice job.
I've tried to do that with all the properties. I just can't dictate what happens after I sell them.
I think that trailer on
The trailer went back.
Sorry.
Thank you for coming back.
Sure, we just,
You were a petition signer, is that
Yes,
right?
I'll put us
I would like to bring you up because I have some questions for you. So you're not being called as a witness from either side,
Okay.
but I would like to dig into issues of signers a little more. So Carolyn, what was your last name?
Steinsick.
Okay, and I did get that earlier. Do you solemnly swear, subject to the penalty of perjury, that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right.
Sorry, I'm still a little snowblind.
That's okay. And I see that you signed, I looked earlier and then I
Should be
forgot which
number one, the
petition
first
you
one.
are.
She's on A. We're up to E, right?
There you are. You are signing on petition line 35 on what's marked as Exhibit A. So can you tell me who presented the petition to you for signature?
Jeff did.
All right. And was Beverly present?
No.
And do you feel like you understood what you were signing?
Yes.
Okay. And you had the opportunity to read it,
Yes.
obviously, and understood what you were
Yes.
signing. Okay. Thank you. That's all I wanted to know.
Okay.
I told you we're quick.
Okay.
Was there any questions from either party of her?
Okay.
Okay. Thank you. All right. We'll turn it back to you for your next witness.
All right.
Oh, let me swear you in, Josie. You solemnly swear, subject to the penalties of perjury, that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
All right.
Okay, Clerk Hart, on October the 2nd, I believe it was, I submitted a notice to you. Do you have a copy of that notice with you by chance? The notice of the petition for your approval?
I have it in my office, yes.
Could you get it? And
Let
the
me,
proof also.
why don't we get a whole idea of what record you're asking for?
Do you want the notice and the proof and all that brought in? We can bring it in right now. Of this petition? Or
No,
Not
because
find
I'm
that
not,
true.
because
Okay.
that was already determined
Okay,
to
good.
be okay before I stepped in.
Cool beans.
And it's not part of, not part of what I'm being asked to do today.
All right, then we'll start from here.
Exactly.
Okay, on what was the date? Let's give her Exhibit A, would you please? Exhibit A. We'll call that the mandated petition with 51 on it. What day was that filed with you?
It says October 7th, 2015.
That was the date it was approved by you.
It was filed.
That was, what does it say on above October 7th, 2015?
There are no other dates on this.
Right above your signature, what are you signing? What does that date mean?
Right above my signature,
Huh?
it says April 5th, 2016. There's no other date on
Doesn't say approved for circulation
here.
bond?
October
Oh.
7th, 2015.
So would you read those words, please?
Approved for circulation by Josie Hart, October 7th, 2015.
Okay, you had that petition 5 days prior to that, had you not?
I would have to look at
Okay, but you had seen it before. And that was approved for circulation. What date was that petition turned into you in its present condition, signed with 51 signatures?
I would have to look at my file and see when we brought it back in.
Wasn't it October the 12th of 2015?
I would have to look at my files.
Please do.
Yes, you bought it back in October 12th.
Okay. And that was the date it was filed with you, correct?
Yes.
Okay. Are you familiar with 3111-109, that statute? Are you familiar with that one? It's about signature verifications and statements of sufficiency.
Yes.
Okay. Do you need a copy of it, or does it not say that? Is it all right if I read it here from?
Sure.
Or why don't you, if you have it?
Why don't I read it? What is 3111?
111-109.
Oops. It's titled Signature Verification Statement of Sufficiency. Sub 1, the clerk shall inspect timely filed initiative or referendum petitions and the attached affidavits, and may do so by examining the information on signature lines for patent defects, by comparing the information on signature lines against a list of registered electors provided by the county, or by any other reasonable means. Sub 2, after examining the petition, the clerk shall issue a statement as to whether sufficient number of valid signatures have been submitted. A copy of the statement shall be mailed to the persons designated as representing the petition proponents pursuant to section 3111-1062. Sub 3, the statement of sufficiency or insufficiency shall be issued no later than 30 calendar days after the petition has been filed. If the clerk fails to issue a statement within 30 calendar days, the petition shall be deemed sufficient.
30 days from the date of that filing would have been what, Clerk Hart?
November 12th?
Sure would have. And I believe 3111-1093 says, the statement of sufficiency or insufficiency shall be issued no later than 30 calendar days after the petition has been filed. If the clerk fails to issue a statement within 30 calendar days, the petition shall be deemed sufficient. Is that your understanding?
Yes.
Okay. Did you file a statement of sufficiency or insufficiency for that petition, which we're calling Exhibit A?
I did on December 16th.
Is that within the 30-day requirement of the statute? Which you just said was November the 12th.
Correct. But in this case, I believe you have to factor in the district court, when it's in the district court.
Okay, I would ask you to have a look at, which one's the court order?
The court order E here. There we go.
Can you find in there anywhere where you asked for or were granted a stay of any kind? Where the judge issued a stay? I'd let the record reflect that the clerk's reading the order.
Sure.
Can I get one more now?
Sure.
They never looked so good until you got them. Are you minding those trees that grow over the garage? Because that's what ruined it, the garage roof the first time. Was those trees going over and falling on the roof, and that's really on your side of the property. Because Brent and I measured. Yeah, but just mowing it, maybe.
I did have trimming in.
Oh, you did. It just looked, too bad you didn't own it when I had it. When I owned the garage, because I would have liked that a lot. So, because I do appreciate it.
I don't know where the garage goes to the, I don't think he cared anyway if I trim something back.
Oh, no. They just, but he would care. The trees fall on the roof like they did it. That's what caused
May I
all
see
that.
E back if you're not using
Oh,
it?
That's it.
Oh, I got it right here.
So in the last statement of this, it says, this order is also not a prejudgment of what the clerk may determine regarding the adequacy of the petition if a protest is filed and her duties require that she fill the role of hearing officer in resolving that protest. I see that as we can continue with it, and there was still time to protest, and there was still time to let notice sufficiency.
So, okay. So I would direct your attention then, may I see it, please?
Get back.
So let me just go ahead and read, that was the last one, and it says, the court finds and declares that at this time, the clerk cannot halt the initiative process with regards to this ordinance, and that the procedures set forth in Article 11 are to continue to be followed. As noted above, the court does not make any determination regarding the validity of the proposed ordinance, nor even whether the petition or a section of the petition proposes municipal legislation in violation of the Colorado Constitution. As such, determinations fall outside the court's jurisdiction at this time. This order is also not a prejudgment of what the clerk may determine regarding the adequacy of the petition if a protest is filed and her duties require that she fill the role of hearing officer in resolving that protest, period. And
Why we're here today.
how do you find a stay of any kind within that paragraph? Where do you find that? How do you find it? Does it say that?
Because it says to continue.
Read the whole sentence, please.
This order is also not a prejudgment of what the clerk may determine regarding the adequacy of the petition if a protest is filed.
Read the first sentence, please.
The first sentence.
The first sentence of,
Number 16.
yes, please.
The court finds and declares that at this time the clerk cannot halt the initiative process with regard to this ordinance, and that the procedures set forth in Article 11 are to continue to be followed.
Okay, right there. Article 11, 3111. So 3111-109 specifically on the statement of sufficiency is to be followed, correct? And 110 also, correct? And all the rest of them. The judge said 3111, that's the entire process, is it not?
Says Article 11 are continue to be followed.
Mm-hmm. Did you follow those?
That's what we're doing.
Did you follow them as it regards to time?
I believe I did.
Huh?
I believe I did.
Okay, let me refer your attention then. Where did E go again?
E?
E. E.
That's okay. We can
keeps
share.
running
We
away
can
from
share.
me. Okay, so. Would you please read numbers 13 and 14 of the court's order, please?
In this instance, the clerk indicated that she is rejecting the proponent's ordinance because it does not propose municipal legislation.
Slowly, so we can understand it, please.
Under the state constitution, it appears that she is doing this in the exercise of her role as clerk under 3111-106, which empowers her to initially pass on the form of the petition. The difficulty is that she already approved the petition for circulation. It has been circulated, signed, and resubmitted for signature verification. The authority of the clerk is limited. When the petition is initially submitted,
Was that 14 you just started to read?
yes.
Okay, go ahead.
When the petition is initially submitted, the clerk shall approve or reject it no later than 5 business days following the date on which she received the form and the first printer's proof. This decision to accept or reject includes the determination of whether the petition proposes municipal legislation. 3111-106-1. The legislator has used the word shall in connection with this decision, thereby emphasizing the importance of timely compliance. Board of County Commissioners versus Edwards 171. Blah, 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 blah.
The word shall is important to the court in this order, is it not?
Yes.
Okay. Is the word shall appear 3 times in 3111-109?
Does it?
It does. Does it also appear in 3111-110 as far as time goes?
I don't know, does it?
It does. Okay. So then, you find no stay in that, is that correct? That you didn't find a stay within the judge's order? Because I didn't. Did you find a stay? Did you find the word stay within that order?
The word stay is not in this now.
Okay. Did you ask in your petition to the court for a stay?
I don't believe you did.
Were you granted a stay in the judge's order? Yes or no, please?
Yes.
What? So, you asked for a stay in your pleadings?
No.
Okay. Were you granted a stay by that judge's order?
Yes.
Please show it to us.
I think she just answered that previously, and
I find no such.
you can answer it again then. I've got it in the recording, but go ahead and answer it again in your last. It was when you were talking about the last paragraph and reading that context.
I believe in the last paragraph it does. This order is not a prejudgment of what the clerk may determine regarding the adequacy of the petition. If a protest is filed and her duties require that she fill the role of hearing officer in resolving that protest.
Didn't you also feel when you made the pleading to the court that you had the right to object or stop the petition because it was not legislative in nature? Did you not make that assertion in the district court?
Yes, we did.
Okay, we want to read us what the judge's answer was to that?
Let me back out of that because I specifically want to avoid trying to do anything that the court has already done. So I will not be dealing with the legislative or not legislative aspects
My
of
point
this.
goes to time,
Okay.
specifically to time.
Okay. Then continue.
And so what it goes to is when you brought this lawsuit against the People's Ordinance, it was under the basis for the grounds were that you had the right to object as the clerk. Is that correct?
I had a right to reject on the grounds that it does not propose municipal legislation in the state constitution.
Okay, and what was the judge's order to that?
It appears that she is doing this in the exercise of her role.
No. Well, isn't it true that the judge said your time to protest was before you approved the petition for circulation is basically the essence of that order, is it not?
The time for me to reject it was before I approved it for circulation, yes.
Okay, very well. So now here we are in the same situation of time. The time has expired, has it not, for both the statement of sufficiency under 3111-109, which is now deemed sufficient by default, and 3111-110. 40 days have passed since the date of filing on both petitions. Is that correct?
I don't believe so.
Okay, would you like a calendar?
Let me consolidate what I think I've heard, because I think I'm hearing some repetition.
Okay.
So I understand that your allegation is that it's not timely filed because it exceeded 40 days from the date the petition was submitted to the clerk.
Saying shall words.
Yes.
as-
So I understand you clearly that is what your claim is. What I hear you saying is that you gave the window of protest to start based on the date of that court order 40 days forward, which happened to be January 25th, so you believe it to be timely because of that. And because of the content of that court order that specifies the court is not going to step in and do your job for you, essentially, to put it very, very concisely. Okay, so I have heard those arguments. Those are going to be important things that I weigh out in making my findings. So I don't think we need to beat that to death.
Okay, well then in that case, may I see those documents regarding what you put out and published? Let's have a look at those, get them in evidence up in here. All of them, please.
And this was mine.
Okay, let's mark this one F if we could, please.
All right, so what I'm looking at is a document titled Notice Regarding Setting of the Election and the Protest Period for the Petition for Initiative Election submitted by Jeffrey Russell Fike and Beverly Langley. And it goes on to give the dates and the background, and the bottom line is it says, accordingly, the final day to submit such a protest is January 25th, 2016. And that was number F that we marked that.
It's a letter.
It's what?
It's a letter.
Yeah, number F.
No, there it is. Yeah. Okay, and then I would like to say, and I would like this submitted as G, please.
Okay.
Referred to by F.
And this that I'm about to mark, Exhibit G, is a statement of sufficiency concerning the petition for initiative election submitted by Jeffrey Russell Fike and Beverly M. Langley on or about October 19th. And this says that so what this tells me is that the clerk, after the court order, inspected the petition and started the clock for the 40-day protest period.
That's important to this case.
It is. It's very important.
Okay. And
That's F and this is G. Number G.
Number G, huh?
Yes.
All right. And this item G, I'll just go ahead and read it out loud so everybody can hear it and gets on the record. This is a statement of sufficiency concerning the petition for initiative election submitted by Jeffrey Russell Fike and Beverly M. Langley on or about October 19th, 2015. I would submit, ask the court to take judicial notice of Exhibit B.
This hearing officer will note our exhibits,
B.
not the court.
B, not A. B is not the mandate
B.
petition, but the one with 6 signatures. That is
The
specific.
second one
Right,
that was
which
received.
is another blatant attempt, I believe, to skirt the mandate. The town of Arriba clerk, or the Arriba town clerk, in accordance with CRS 3111-109 and the order of the Lincoln County District Court dated December 14th, 2015, herein state that I have inspected the initiative petition as filed by Jeffrey Russell Pike and Beverly and Langley, as well as the attached affidavits, and have determined that a sufficient number of valid signatures have been submitted. The proposed ordinance shall be submitted to a vote of the registers and electors of the town of Arriba, Lincoln County, Colorado, at the general election to be held on April 5th, 2016. Within 40 days of the date of this statement of sufficiency, a protest in writing under oath may be filed in the office of the town clerk by any registered elector who resides in the municipality, setting forth specifically the grounds for such protest in accordance with CRS 3111-110, dated December 16th, 2015. It's signed Josie Hart, town clerk, certificate of service, that in your capacity as town clerk, you certify that you mailed to Beverly and I, okay. So, that's that. Is that correct? Is that what I just read is what it says? All right, on, where is the ordinance? 110.
Well, you know,
I might have seen that.
Here it is. Got it?
I was gonna say,
I remember
We
being
had it all the time.
I knew it went that direction. That was-
And that is Exhibit D. Could you please tell me wherein that states 40 days from the date of statement of sufficiency? Or does it say from the date the petition is filed?
He's dangerous, he's been out there twice and came back in.
That's because he can't see when he comes back. You don't gotta look at him.
No, they were saying you were dangerous because you went out 4 times. I'm counting.
Two standards.
Within 40 days after an initiative or referendum petition is filed, a protest in writing under oath may be filed in the office of the clerk by a registered elector who resides in the municipality.
Okay, and then would you read on Exhibit G, your document right there, what did you tell the people that statute said?
Within 40 days of the date of this statement of sufficiency, a protest in writing under oath may be filed in the office of the town clerk by a registered elector.
Where did you get that idea from? It's certainly not in the statute.
Working off the court order.
Okay. Let me bring you the court order back. Where in the court order does it state anything about 40 days from the statement of sufficiency?
Should be on top there.
Can you please find that?
It doesn't.
It doesn't. So you made it up, in other words, correct?
No.
Okay, you misconstrued it then.
I think what she's already answered is that was her interpretation from reading the conclusion, that concluding sentence.
No, this is a little different thing.
I understand what you're saying, but
This says specifically,
Sure.
it's citing a statute that says within 40 days of this statement of sufficiency.
and
Citing Colorado revised
Yes.
statute. That's real bad. Not supposed to do that.
it's in the record that you're noting that, and I'll
Okay,
take it into
I'll move on.
consideration.
I'll move on. Okay. Now, That was G. Now, on F, Exhibit F here, and this is notice regarding setting of the election and the protest period for the petition for initiative election submitted by Jeffrey Russell Pike and Beverly M. Langley. The Arriba Town Clerk in a court, wait a minute, hold on, let me back up to G. Just a second. In the judge's order, let's get back here.
This is E.
E. Number 1, would you please read number 1? These are findings, is what that would be called, is a finding. It's not an order. What did the judge find? What's his first finding?
This case is legally prosecuted in an informational manner. Defendants have filed a petition for a proposed initiated ordinance that they wish to have included on the ballot at the Town of Arriba general election in April 2016. The Arriba Town Clerk approved their initial petition for circulation on October 7, 2015. The defendants proceeded to gather signatures and filed them with the clerk on or about October 12, 2015.
Okay, do you even find that the court found the October 19th petition? Do you find that anywhere in the judge's order? Because I submitted it in my answer, and he most specifically did not find it.
I'm sorry, can you say that again? What you asked the judge to
I'll try to
find?
put that in English. Okay.
I've only seen the order, and I'm trying not to go too far down that road because this order is relevant in terms of my decision regarding the timing. It's not relevant in terms of the content of the rest of the order, so I'm trying to make that distinction for myself.
The pleadings were such that when Clerk Hart filed her complaint, attached to it was your Exhibit A, the mandated petition with 51 signatures. When I filed my answer, which was a motion to dismiss and or a motion to compel the clerk to do her job, attached to that was what you have in evidence as Petition B, containing 6 signatures. The judge hearing the evidence, denying my motion to dismiss, but granting the motion to compel, did not find what you have in B. He only found A in the judge's order. Why? I don't know. I ain't the district court judge.
Yeah, I'm not going down that road.
It's a fact that what you have in A is found in the judge's order number 1.
So what are you asking?
What I'm stating here is relative to this bogus statement of, I submit this error statement of sufficiency specifically goes
to the
B, which was not found to exist by the district court in 15 CV 30,018.
Okay, so I have in my record that you are alleging that the statement of sufficiency was based on essentially the second petition rather than the first.
Which was in evidence.
And that the 40-day clock was incorrect in beginning from the statement of sufficiency and not from the date of filing. Is that a summary?
Say that one more time.
The 40-day clock for the protest window stated on that notice says that it's 40 days from the statement of sufficiency, where the statute said it's 40 days from filing. And that's your argument.
That is correct. That's one argument. Second argument is that the untimely statement of sufficiency goes to the petition filed October 19th, which was not even recognized by the court order, but yet in her first paragraph she's referring to the judge's order.
Okay.
Making that up as well.
All right. I've got all that, and I don't think we need to talk any more about that.
All right.
What else?
Well, let's see.
I got a couple questions. For Josie.
Yes.
You're the clerk is part-time, right?
It was part-time in December.
In
It's
December.
currently full-time.
Currently full-time. You also raise a family, is that correct?
Yes.
And help your husband with a business that he's trying to grow? Have you had any municipal training?
I have not.
Any official schooling this way? So the knowledge that you gain is through your own understanding, your own readings?
And consulting with other clerks and a town attorney.
So when you do have a question, you ask experts.
Yes.
You ask somebody from Alamosa to come here as an expert. You ask possibly a mayor, neighboring clerks, or your town attorney.
Yes,
Do you ever get instruction from your town attorney?
definitely.
Because he has a greater understanding of municipal law than you do, is that correct?
Yes.
And is it true that, strike that, so when you get instruction from your attorney,
I'm gonna object to privilege there before we go bringing up a can of worms we don't need to open.
I think we're just talking about, your allegation was that there were incorrect things in the notice posted on the door. And I think where you're going is, you asked the question, where did you get that information? And you're delving
I see.
into that
Perfect
a little
question,
more.
Jake. Perfect
Is
question.
that
yes.
accurate? Okay. You
So
can-
the
you can
instruction
continue.
to wait until a judge's order came from somebody else, rather than your true understanding of what municipal law, because it probably gets rather confusing. Is that correct?
Yes.
So your timeliness may have been affected by the expert opinion of somebody you asked for guidance for.
Yes.
And that is the judge's order dated October 19th, 14th?
The judge's order was dated December 14th.
14th, December 14th.
The judge's order.
That's where you got your instruction to start your 40-day clock from that point.
Yes.
Okay. Thank you for the clarification.
And to clarify, nowhere within that order did it say it was a time to state the clock, start the clock, or that 40 days was from the statement of sufficiency, did it?
Not in those words.
Correct.
But it did not also say to start retroactive from the date you filed the petition.
I think that's the question. That is the heart,
You nailed it, Rick.
heart of the
There's
question.
The statute clearly states it's from the date of filing.
So
Yeah.
That's the end of
And
that.
that's going to be my hard work for the next 5 days.
Exactly.
Sorting through
I have
that.
some
So
precedent for
I
it, if you'd like to.
appreciate your digging that information out and
In
bringing
summary,
it
I've
forward.
got
So
several cases for
Okay.
you.
another question back here.
I think you were saying that she hasn't had training to kind of okay what's being done. And with that said, if you have enough inside you to ask for a Christmas bonus, but you can't understand what's going on, you should have asked that years ago when you first became the clerk for more learning ability. That's
What is your question to the witness?
My question
Don't
is,
No,
you feel they ever
Beverly's
gave that
asking
to
a
you?
question.
But did you ever ask? Did you ever ask to go to classes from your initial date of getting this job?
The very first year that I was here, they wanted me to go to classes, yes.
Okay, but you didn't?
I didn't.
Okay.
for a reference point for everybody in the room, at that point when you were town clerk and they asked you to go to class, was there anything happening in your life? Did you have a child sick?
oh, yeah.
Not at that time.
Was she recovering from chemo treatments as a...
Actually, when I'm talking about like in 2008 when I first started.
Sorry, that's the... I have a question.
Yes.
Okay. Clerk Hart, let's talk about your education for a minute. Did you go to public school and graduate high school?
I did not go to public school. I was homeschooled and I did graduate, yes.
Through a GED program, I'm gonna guess?
No,
No.
I got my diploma through a homeschool curriculum.
Through a homeschool curriculum. Do you remember the name of that?
It doesn't matter for this
Okay.
hearing.
All right, but you have had no schooling nor no formal schooling like our master clerk has here.
No, I haven't.
But you were offered that training and you declined it, is that correct?
I did not decline it. It just never got done.
You got done. What exactly does that mean?
It means I said that would be great, and then it never got put into effect.
So you've been clerk since 2008, is that correct?
I was clerk from 2008 to 2012, and then I had to stop for 2 years.
And then when did you become clerk again?
2014,
Why did you become clerk in 2014?
because the previous clerk left the job.
Were you on the, that previous clerk was your sister Stephanie Bell, was it not?
Yes, it was.
Okay. And during that time in 2014, there was an election taking place, was there not?
Yes, it was.
And part of the reason you stepped in to take over, wait a minute. Were you not on the board at that time as a trustee clerk or a clerk trustee, or somehow that's referred to in the minutes of the April 2014, I think it was April, yeah, March, April, and May 2014 meeting minutes for the town of Arriba, regular and special. Weren't you the clerk trustee then?
I was the trustee up until the election.
When were you voted in?
Is this relevant to the order?
I'm waiting to hope it is, but
Yeah,
I'm not convinced. Can you get
I'll
to the
elaborate
point?
on it. Yeah, in other words, so the clerk has no special training. Okay, there is some now, I believe, required by statute, but that's
No.
up to you.
There's not.
And then, but the clerk, what I'm getting to, when you became town clerk, you resigned, and then your sister took over Stephanie Bell, correct?
Yes.
Okay. And then was there not a plan, an action plan for the town of Arriba during the 2014 election to have you step in to have another official, much like Judy here, appointed because of the debacles of your sister?
Well, I'm going to cut this off. This has absolutely nothing to do with this petition.
Okay, very well.
Because I understand that you are calling into question her knowledge and
Yeah.
experience,
Yeah.
and I think you've made that clear.
Okay, good deal. Well, if
So-
that's asked and answered, then
It is.
we will.
More questions?
Can I ask you a question? You didn't, okay, he was asking about giving any classes, but you never went to classes, but that was because nobody has ever questioned anything that the board or you have done until Jeff.
That's correct.
And I think that's irrelevant too for this hearing.
Now, here we go.
Hey, can we get recess now?
I think I would like to crank through and wrap up because I need to get on the
I have
road.
one more
I
question,
need to be
I'll
out of
let
here.
and let you go.
Okay.
Clerk Hart, regard with swearing in Jake, Michael, or Mitchell. How do you pronounce it?
Mitchell.
Okay, I thought so.
Like Rich.
Mitchell. Okay, when you swore him in, did you give him an oath?
I took under oath as being in front of as a notary, that oath at the bottom, under a notary.
Okay. And are you a party to the action in case number 15 CV 30018 before the district court on the People's Ordinance?
Is my name on there?
As town clerk, in your capacity, yes it is.
Yes, I am.
Okay, does his complaint come under the same ordinance? The People's Ordinance, is it the same subject matter as in the case of the district court?
Yes, it is.
Are you you're named in that? Are you familiar with the rules of notary public? Do you know about those rules?
Yes, I do.
What is the one thing that you cannot do as a notary? Or one of the things you cannot do as a notary? Isn't it you cannot notarize something that you are a named participant in?
And I think I already have determined in my mind that court action is separate from this hearing. So I understand the question.
You see the subject matter?
I see the subject matter, but I'm not inclined to explore that
Well, we'll let the
here.
Secretary of State
Yeah,
determine
and
that.
exactly.
Okay, I don't have any more questions. Do you, Jake?
Not for Josie.
Okay.
Okay. I will give you both a brief opportunity to wrap up.
Okay.
I don't want
I'm
to...
going to the potty first unless you beat me to it.
Beat you to it.
Other than that, is it over?
Other than that, we're going to be over.
It takes me longer.
What you can expect from me, the law requires me to have a decision to you within 5 days, and remind me when your next town board meeting is.
It's Monday.
February 8th.
Monday. I will have it prior to that board meeting.
Awesome.
And is it in the
You better
evening?
double check.
Is it in the evening? How much time do I have?
I don't have my.
Well, we got a pot hearing at 7, and then the regular meeting's at
Okay.
7:30.
Okay, you'll have my decision
believe-
prior to that meeting because that'll be important for the timing. Yes.
I'd like to ask Jeff what his thoughts are on the marijuana bill.
That's not relevant to
Yeah,
this
let's not do that at this hearing.
at all.
You know what, we need,
That's not relevant
we need
at
to
all.
be able to talk and discuss things at town board meetings, and that's not.
Let me throw something out that's completely irrelevant to this hearing also.
We were just conversing.
It's your turn.
But what I see here is a lot of really people who are concerned about their town, and that you have different ways of approaching it. But really look for that opportunity to talk.
We're
Really
going the
do.
same way, but we can't. I mean, we can't seem. You would think out of 6 people that we're constituents to would say, you know, we really need to talk and take some time.
And the frustrating thing for
But that's not
government,
done.
the frustrating thing for government is that they're under a structure for their meeting organization also, and it
So when are we
doesn't.
supposed to discuss the things that we care about?
I think what you should recommend to the board is a public forum or a work session of some type where people can air their preferences one way or another, and do that in a good.
No, he
Okay, let's
made
what do you-
They do give
items
us 5 minutes, but last couple of meetings, they've asked for that to be removed.
or whatever.
The question and answer.
You know, the challenge, and this is completely out of, I consider us in recess right now. The challenge for the citizen comment at a board meeting is necessarily limited for their purposes. But do have those
If
conversations.
you direct us to 5 minutes, it's quite a time.
It is. You can say a lot in 5 minutes.
But you can also fill it with a bunch of.
And that's why it's a challenge procedurally for the board. And I don't know this board, but I know boards in general, and they don't want to disenfranchise opinions.
There's a lot of frustration and a lot of entitlement.
No,
Sure.
well, not as far as
It's not going to
smoking.
go away overnight.
Yeah, you're not alone. It's a hard thing.
Yeah.
Okay, we were just in an unofficial recess there chatting about other things, so we're back. We're back now. Closing statements. Would you like to make a closing statement?
Yeah, I would. From the beginning, I said that we should be a people governed by ourselves. I believe we have the framework to do that.
Constitution.
And we also have it in our own ordinances through an election process to elect the members on the board that are not doing the job that we don't think they should be doing, or doing the job we should think they're doing. And we have it in the ordinance process through the hearings, which we've all participated in some form or another, either directly as a board member or as a participant, objecting to what your points are heard. If, obviously, the proponents will not withdraw the petition, I encourage them to do what is stated on that 3rd page of the amendment, is people sign this ordinance to get it considered. And so let's fully consider it with all the people of the town and not just 50-some people. There's 136 registered voters in the town of Arriba. Let them all have a voice. Let's put this on the ballot so that we can make sure that if this is what people want, I'm speaking out of turn. If it's not what they want, here I am to speak on the other behalf.
And just to clarify the procedure, that's fine. To clarify the procedure after today, once I make my ruling, if I rule that it is valid to move forward toward an election, the next step is for the board to take that action to set it for an election. They also have the ability procedurally to adopt the ordinance without going to an election. That's their call, and that's why I want my decision to you before their board meeting on Monday. From that point, if I were to say that the petition is not eligible to move forward, that there were some valid elements within the protest, that halts that part of the process, but it's still a challengeable decision within the district court. So whoever's unhappy with my decision either direction can take my decision to the district court.
Where we're already at.
It's related. The subject matter is related, but it is a separate matter.
Right.
So, closing statement from you.
All right. Okey-doke. First of all, this hearing today was held pursuant to 31-11-110. Okay? It was not timely filed. The date for that filing was, the last date for that filing was November the 29th of 2015. Okay? And then the district court found the October 12th, 2015 petition, the mandated petition. Now, mandate, which is going to be something I think you're going to have to rule on as well. Since,
No.
well,
no.
A mandate means it goes by a percentage
Yeah.
of the voters in the last election, which were 62. As a matter
And
of fact,
what statute
enter
would I
that.
find that as?
Josie, you're going to find
No.
that in the Constitution,
Okay.
the Colorado Constitution.
You asked me that earlier, a mandate.
14
I said it was because after
abstractive
she
ballots, please.
gets the signatures verified. But it's the percentage, the amount that we had.
And I don't see that as an element of this particular protest. No one has
It
brought
goes
that up.
specifically to whether it goes to the ballot or it is a mandate.
Okay, and that will be up to your town board then at their meeting.
He wants the abstract.
Of,
Vote.
no.
You asked for it.
No, no.
What do you mean, no? I'm going to protest the abstract of ballots determines, and it's germane to this subject.
No.
It is germane in as much as it establishes the voters that have participated, that you measure the mandate against.
I am not in a position to say whether this is a mandate or not.
Okay, I
That
would
is the
like to
board's
bring it
actions.
into evidence.
No, no, because it's not my authority.
Why should we?
It
It's
goes
not my
to the
authority at all.
petition.
It goes,
Let Jeff finish his comments.
It goes, and I'm going to object strongly and put you on judicial notice to the Constitution of the State of Colorado, specifically Articles 2 and 3.
and how is that pertinent to this hearing?
Because what we have is, you're going to determine whether it goes to the ballot, and I'm telling you it's a mandate.
I am going
It's
to
a veto
determine, I am not determining whether it goes to the ballot.
Oh,
I am determining whether it is sufficient to proceed in the process.
Okay,
the
and this goes to
process-
sufficiency.
The process, in what you're saying now, that process is a mandate, not an election, is what you're saying.
It appears that way,
That's
but
outside my purview,
is it outside of your purview?
clearly.
I would like to bring
This
in...
hearing, no. You can't give me more authority than I have.
Okay, very well then. All right, then let me finish up.
Okay.
So, that again, I believe that petition is a mandate. Also, no stay was asked for by Clerk Hart in District Court Case 15 CV 30018. It was neither asked for nor was one granted. 31-11-109 is germane here. The word shall be deemed sufficient by default is applicable in 31-11-109 parenthetical 3. 31-11-110, the reason we're here is 40 days from the date of filing. It is not 40 days from any date of sufficiency as somehow created and misstated by the clerk and published that way. Okay? It was an erroneously published statement of sufficiency. The time for protest expired November 29th of 2015. And I would ask that this protest is not timely and is not germane. And also I would ask the court to take judicial notice of the following Colorado precedents under the Colorado Constitution for Jeff Pikes and Beverly Langley's petition for initiative election approved for circulation on Town of Arriba by Town of Arriba Clerk Josie Hart on October 7th, 2015. And to be kind to our guest, I'm going to submit that as evidence, so you don't have
And
to write it down.
this is what,
Those are, that's about 12 different,
okay, so these are your legal arguments
those are
for
some
what
of
you
my
just
legal
stated.
arguments.
Perfect, thank you.
And that's where you'll find the mandate, so that's
Okay.
why I was hoping.
It is helpful to
but
have
you
that
need to have
information.
that abstract of ballots to establish the number to work from. Without it, you're
Once-
kind of blind.
I will not be the one to determine that. It's valid information, and the board will need to have that by the next meeting, and I'm assuming the attorney will be interested as well. I don't think that's within the purview of my
Can I-
decisions here.
And with that, I'll
Can
rest.
I ask you
Sure.
how you became involved?
This is what I do.
I mean, did they,
This-
yeah, okay, this,
I am a retired clerk, and after I retired, I set up a consulting business to do any sort of thing that
retired
was
town clerk,
Yes.
retired grocery clerk, I'm sorry.
municipal clerk. I was
Okay,
with a
municipal
city,
clerk, okay.
city of Alamosa. So I use municipal because some are cities, some are towns, some are home rules, some are statutory.
Okay.
So there's a distinction. So my background is 27 years with the city of Alamosa, and now I've got 2 years into consulting business.
And it's a hobby.
And no, it is my career. It's exactly what I do. So I'm happy to be here and do the service.
Okay, so you were asked by the town?
Yes. I was referred from another town that I had done some election work for. I was referred to Josie by the town of Monument. Is how I got connected.
Okay.
And you sure it wasn't LinkedIn, because you got a hell of a beat on there?
Yeah, well, it's a little outdated. I need to update that.
Mine too.
Well, thank you for your time.
Oh, I
Thank
would
you.
ask before we adjourn that you mark that exhibit into evidence, and then I would like to pay the clerk for copies of all those exhibits.
All right. Then, I just wanted to say out loud for the record what I'm taking as evidence here, which I think is going to be H. And this is Mr. Fike's case law references for his arguments here today.
Yeah.
Yes.
You mentioned that you were going to go through the signatures individually on your own. Is that?
What I was after with that evidence was hearing from those people who were present who signed that. I'm not going to go back and redo any of Josie's prior work. But what I wanted to hear that I think is relevant and will feed into my findings is how the petition was circulated and under what circumstances they signed it. So I think I did get information that I needed on that.
Okay.
Hope we did it right, because we sure as heck tried.
Most of it was a good time doing it.
Huh?
We had a good time
Oh,
doing
we
it.
did.
And talking about it.
Keep talking to each other.